For pronouncement of judgment, item 24 and 25.
Green 10. Green. So we have dismissed both the writ petitions. We held that 3/8/2016 lays down a discrete and dynamic mechanism for collection of quantifiable data, which is also the opinion expressed by the court in IV Gohai Dasgupta. So no scope of interference.
My Lordship, with the concern of other side, I beg to mention item number 20 of today's list, my Lordship. I am on behalf of B. Purukaistha. Kindly this matter may be adjourned for 2 weeks, my Lordship.
Who is for the other side?
My senior,
The other side. You already taken consent.
yes, my senior advocate B. Purukaistha has taken, my Lordship.
Adjourn.
Highly obliged.
I get to mention item number 18. I have
What
taken, my lord, I have taken consent from Mr. Akadi Chaudhary, my lord. Nothing may kindly adjourn the matter, my lord.
Adjourn.
My lord.
Lordship, I'd like to mention item number 14, the daily list. Where the matters, similar matter is pending before the apex court. My lord may not like to take up the matter.
Similar matter is pending. The concept of the parties have submitted that identical issue involved, the issue involved in this application. Appeal is similar to the issue involved before the Honorable Supreme Court, and the decision of the Honorable Supreme Court is awaited. So the matter may be adjourned for 12 weeks.
Oblige, Your Lord.
My lord, I beg to mention item number 12 and 13.
Yeah,
My lord, issues raised in these cases are pending before the Supreme Court, my lord,
same order,
in series of cases.
same order.
All right.
May I please, Your Lordship? Lordship, I beg to mention item number 23 of today's list on behalf of the appellant. But I have taken the consent of the other side, my lord. He is very much present here. My lord, there are 2 other connected writ petitions on the similar matters. And I pray, my lord, let this matter be adjourned and taken up along with other 2 writ petitions. The other 2 writ petitions, my lord, that is,
Petitions or appeals?
my lord, writ petitions.
Writ petitions.
Writ petitions,
One
my
of
lord.
them, we are the petitioner.
Issue is
Request of the party, concept of the parties, this appeal along with.
my lord,
So and so,
WPC 6916.
give the number to the,
My lord,
along with so and so, after 4 weeks.
I'm so obliged.
My lord, I am praying for listing this writ appeal, my lord. This was, my lord, listed on 3rd of April. Due to paucity of time, it could not be taken up. And it was refixed on 8th of April, my lord. But my lord, inadvertently, my lord, the order was typed as well as 8 May, my lord, 2024. I have some,
Come in,
my lord, I have some urgency because, my lord,
urgency, otherwise also it will go in April. No, in May,
my lord,
let it be on it.
My lord, I beg to mention for listing of a writ appeal, your lordship, there is a stay offered. The learned single judge's order was in our favor, your lordship, but that has been stayed, your lordship. That is operating against us. Lordship, it was last listed on 22nd of March, your lordship, but it could not be taken up on that date, my lord. So can it kindly be taken up in the first week of May, your lord?
It was left over.
Yes, ma'am.
Same.
First week of May, your lordship. Much obliged.
Maybe before lordship, my lord, item number 8, my lord, on behalf of petitioner, my lord,
Eight.
8, my lord. Kindly, Mara, after 1 week, subject
Adjourn.
open notice
Adjourn.
court, my lord.
Adjourn.
Yes, after 1 week, my lord.
May I please your lordship? Lordship, I am for item number 16 and 17.
Yes.
Lordship, kindly adjourn the matter for 2 weeks.
Have you taken consent for the other side?
Yes, your lordship.
Adjourn.
Thank you.
Daily list for admission, item 1 and 2.
Yeah, please, Lordship. I am for the item number 2 one. The other is appeal has been filed by the my learned friend, my lord. Probably on the same cause of action is on the both the cases. In my case, my lord, I have filed the reply to the affidavit of opposition filed by the respondent number 1. That is on back 18/12/2023, my lord. And other question I will.
This physical stamps were introduced way back in July 2023.
Yes.
Yes, madam.
And in the PIL, I don't know in what's your case in PIL, your the concern of the petitioners was regarding the stamps, especially those purchased before the deadline of June 30 of 2023. Now that deadline is now over, and what remains now? Now since almost 8 months, this digital stamps and currency, how can we allow the stamps, non-judicial stamps to be taken into consideration at this stage?
But in my case, my lord, the other issues also there, my lord, because the
What
cabinet,
other issues?
my lord, the cabinet decision, whatever is taken, my lord, the by which the only, my lord, the digital stamp has been, my lord, the introduced instead of the, my lord, physical stamp. And
Everywhere now, everything is going digital. What's the problem in that?
but the other the stamp vendor interests are there, my lord, because they are given 1 lakh of rupees one time, my lord, for their upgradation of their existing to the, my lord, citizen service center by introducing, by installing certain electronic gadgets like the computer and the printers and everything. That cannot be, my lord, possibility to 1 lakh of rupees. And moreover, my lord, you kindly see this.
Admit.
Lordship, in item number 1, your lordship, notice was issued on 4th of December 2023, your lordship. I have not been served any extra copy, your lordship. I am unable to file my affidavit using this.
Who is the
One.
advocate?
Oh,
Who is the advocate for the petitioners in item number 1?
Yes, I'm Nidhi, and today we have served, lordship, already served. I have not received your lordship.
Get the copy served.
Yes. In that case, lordship, one, I also pending for certain correction, lordship,
For what?
and correction, lordship.
Correction in
Correction.
writ petition?
Yes, lordship.
Correction or amendment?
I'm not correction of paragraph 5 of the petition that is pending.
You consider it at the time of hearing. Okay. And copy of the writ petition is supplied to the counsel for the respondents. If not already supplied during the course of the day.
State authorities open.
If not supply all the respondents during the course of the day. List in due course.
must.
Deeply obliged, your lordship.
Item 3 to 6.
May I please, your lordship? Lordship, this matter may kindly taken up to my lord, that's two.
Why?
Lordship, senior arguing counsel having some personal difficulty, my lord. MK Sudhir, my lord.
I am,
IA in this.
I am for item number 3, my lord.
It is a IA file.
My lord, we filed IA for implement. This is on PPP mode basis, it was settled with us. Then they provided a tender. So when they provided tender, it was settled with Mr. A. Then we came to know, we filed an application. We thought that we should file an application for implement. And accordingly, we have taken steps by Dusty also. That's what we have done. Notices served by the last order.
Not at two. We'll take up the matter after some time because I don't think so we'll be able to sit by up to two. After some time. After some time. Call your advocate.
My lord, because I am representing for first item number 3. My learned friends, my friend, Mr. M.K. representing for other 4, 5. So I think his presence may be required. So any date,
We'll
I
wait for
told
some
my
time.
learned friend,
We'll wait for some time.
yes.
We'll take up this matter after some time.
But because he is
in another court, my lord.
in state
So,
consumer.
Whenever he is free, please ask him to come. Pass over for the time being.
Item 7.
Mr. Das, have you seen the division bench judgment?
Yes, Lordship, I have seen. There is a vast difference. In that case, Lordship, that particular candidate, Lordship, they had appeared from the Dr. Sosi Bhushan Institute of Education, Hailakandi, and they had applied before the cutoff date. And their applications were never rejected by the NCT. But here in the instant case, Lordship, the applications were rejected by NCT. The recognition was cancelled. And
Same analogy will apply.
Lordship,
The same analogy will apply in this case. Can't say that there is a difference between once the recognition is granted, all the degrees granted prior to that or after that will be treated as recognized.
no, Lordship, in that case, Lordship, may kindly see their application was rejected by NCT for non-fulfillment of the certain
But
conditions.
later on, the institution was granted recognition.
Yes, subsequently it was granted. But
Subsequently,
when
then
he was a student of 96, 97 batch, and their application for recognition was rejected by the NCT. Lordship, may kindly
for
peruse
all
that two orders.
purposes, it would be treated as recognized. This is our view. We have taken that.
Ratio of that judgment will be applicable.
Will be applicable.
Ratio will be applicable here.
Lordship, in that particular case, Musawir Ali's writ appeal, Lordship, your Lordship has given.
You have the copy of the division bench judgment.
Yes, Lordship. Writ appeal number 415 of 2022. 415.
Same facts are there.
Yes, Lord, para 12 facts.
This person in this writ appeal gained the degree in the academic session 96-97,
Lordship,
and recognition was granted to the institution on 13/1/2000.
2000.
Provisional recognition and final recognition was granted on 15/6/2001.
Lordship.
The same.
Lordship, in that case, Lordship, NCT never derecognized the institution.
That's
In this particular case,
inconsequential. That inconsequential.
Lordship, their recognition was cancelled,
That is inconsequential.
and he was a batch from 96-97. And Lordship, 4 affidavits have been filed, Lordship. The NCT, Lordship, the regulatory body has made a specific stand in the affidavit that his BA degree is not a valid degree. But in
As the NCT had rejected, but later on that position has been reversed. Then the
That-
NCT is
that was
recognized.
reversed in 99.
Have you challenged that recognition order by the NCT?
Lordship, I need not, because Lordship, that when he had obtained his degree, Lordship, when he took admission, there was a specific intake capacity of 60 students. In 1996, there were only 60 intake capacity. And Lordship, the department, Lordship, the 4 affidavits have been filed. That was not taken note of by the learned single judge, Lordship.
That is not necessary. Once the court has held that the degree is valid, even though obtained prior to the recognition, then it would be treated as recognized for all purposes. That's what the Supreme Court has said.
No, Lordship, the learned single judge has decided by taking note of a part of the judgment passing the Bhupendranath department. Lordship, may kindly see page 351.
Internal page of the judgment,
Judgment, Lordship.
internal page,
351, Lordship.
internal page of the judgment.
This is a running page, Lordship. Internal page, Lordship, it has 351, Lordship, of the appeal memo, Lordship. Internal page, Lordship.
Page 7 of that very particular judgment.
Page 7 of the judgment.
Yes,
Lordship, paragraph 19, Lordship. A
Paragraph?
plain paragraph 19, Lordship. At the top.
yes,
A plain reading of provision suggests that all such institutions offering a course or training in teacher education prior to the act coming.
Mr. Das,
Lordship.
which is the page you are reading from, running page?
351, Lordship. 351.
Three 51 is something else.
The judgment is annexed in the appeal memo. 361 page.
this
Bhupendranath
Bhupendranath
Tripathi, yes,
Tripathi,
yes, sir.
yeah, next this, along with this petition,
Lordship.
writ appeal.
Yes, sir.
The question of fixing the judgment. Yes, yes,
Paragraph 19, Lordship. A plain reading of the provision suggests that all such institutions offering a course or training in teacher education prior to the act coming into force are entitled to continue such course or training until the application is disposed of, provided such application has been made within 6 months from the appointed date. The consequence of not being able to gain recognition is to the discontinuance of the course. Once an application seeking recognition has been filed by the institution within the prescribed period of 6 months, the institution is entitled to continue offering a course or training in teacher education until the disposal of the application by the regional committee. Once the recognition is granted by the regional committee to the institution offering a course or training in teacher education, the same shall relate back to the date of filing of application. Section 14.5, read with section 14. One enables the institution offering a course or training in teacher education on the appointed date to continue the course or training as the case may be during the pendency of the application seeking recognition, and even in case of refusal of recognition, the course may have to be discontinued only at the end of academic year. So when he took admission in 96-97, this entire paragraph, Lordship, those institutions who have made application within 6 months, this paragraph will be applicable only to those institutions who had made their applications within 6 months from the date, from the appointed date. Now, Lordship, in the instant case, Lordship, their application has been rejected by the NCT, Lordship. Their
When?
Lordship, may I kindly see. Lordship. That was it. At page 176.
They,
6/12/1996. 6/12/1996 and 13/1/1997
6/12/1996.
and 13/1/1997. At page
In
175.
any case, if their, this application was rejected,
Okay.
the institution was supposed to discontinue the course at the
Yes.
end of the academic session.
Yes.
He obtained the degree in 96/97.
Yes.
Then
So that was a 1-year course, so they should have,
ultimately, at the time when this recognition was refused,
okay.
he was pursuing that course.
Course. So he failed in the examination.
In any case, as per the observation made by the Supreme Court, that course was able to be discontinued only up to the end of the academic session. Prior to that, if he has obtained the degree, how can you say that this?
Lordship, he took admission in 1996, and at the relevant point of time, B.Ed was a 1-year course, and he failed in the examination in 1996.
Thereafter, he passed in the year 1999.
1999.
At that time, this recognition and ultimately the recognition was granted. The same analogy will apply.
Well,
Extend किया ना बात से.
and Lordship, the NCT has taken a specific stand in the affidavit that his B.Ed degree cannot be treated as a valid degree. So, and the NCT being the regulatory body, also their stand cannot be ignored. Even the Bikuda B.Ed college, the college has itself said that there was no recognition at that point of time.
Yes. Yes, what do you want to say? Who is appearing for the?
Lordship, I'll rely on the judgment, Honorable Sundar has passed with regard to the fact that course has to be recognized by NCT, not the degree. The submission he makes that he passed in 1999, the degree given by the university, but course was undertaken in 1996-97, the period when it was recognized by, though it was rejected end of the year, that year would be recognized, Lordship, by the NCT, that course.
This is clear.
So, my humble prayer would be my degree at that point of, the course that I've undertaken in 96-97 would be valid degree. Lordship.
Anybody else from the respondents?
Who is for the NCT?
My lord, we have filed our affidavit, my lord, counter affidavit, my lord. Here in this case, my lord, scholars have initially applied on time, my lord, to the 6-month period, my lord. But subsequently, he failed, my lord, the petitioner, my lord. Subsequently, by that time, we have rejected the application for recognition, my lord, which was, again, we have considered and recognized from 1999, my lord.
1999.
Yes, my lord.
So, as per your.
In between, my lord, there is no recognition, my lord.
In between integral period, that period,
My lord.
when this refused and again granted, what would be the position of those degrees or courts?
In that case, our stand is that, my lord, since we have not, there is no recognition, my lord. So our stand is that, my lord, that degree obtained from that year, my lord, is not recognized. My lord.
May I Lordship point out?
Lordship, may I point out one thing, Lordship? Lordship, that particular paragraph which I have read, paragraph 19 of Bhupendranath Tripathi, that last part, that it will be and in the at the end of the academic session, that will be only applicable only to those scholars who had applied within 6 months from the date appointed date.
They also
But-
applied
yes,
within the appointed date.
Appointed date, but their applications, both the applications were rejected for non-fulfillment of certain conditions.
That is what,
No,
para
they did
19
not have
deals with
instruction.
that situation only.
Lordship.
Para 19 deals with that situation.
Para 19, 124. Their applications were not pending, Lordship. Only those applications which were pending. But their applications were not pending. Their applications were rejected.
Where is the order by which it was subsequently granted recognition?
At page 270, my lord, annex D, my lord. One page number, 270. 270. 137.
January 19. Where is that order?
My lord, order is that 269, my lord. Type copy, my lord, and just copy is page 70, my lord. 25/11/1998, my lord. My lord, may I also peruse the page 124, my lord. That is the minor submitting of the ERC, my lord. It starts from 114, my lord. In fact, initially we have referred the matter to the government, my lord, for taking a decision, my lord.
Judgment gives us.
Who is holding the post of principal now?
Look, I am holding the post for last 3 years. Look. I am a regularly, and we both scored 10 marks. Look. And we joined the school on the particular date. Look.
Pass it out.
Lordship, I want to cite some judgment, Supreme Court judgment. Lordship. Lordship.
My lord, also kindly peruse page 114, my lord, that is our minus of meeting, my lord. Here we have referred the matter to the government, my lord. And accordingly, the government have decided, my lord, that degree of the petitioner, my lord, that is at page, my lord, 114, my lord. Relevant is 124, my lord.
Yes.
Page 124, my lord.
Yes.
The serial number 24, my lord. The ERC considered the matter in the light of the directions passed by the Honorable High Court of Guwahati by order dated 3/12/2020 in WPC number 2057 of 2020 filed by Sri Biren Suikia versus State of Assam and observed under the one Sri Biren Suikia petitioner has admitted Bihupuriya PGT training college Lakhimpur, Assam for BEd course in academic session 1996-1997. To the ERC, NCT Bhubaneswar was established at the stage of 1996 and started its regulatory functioning from the year 1997 onwards. The petitioner has admitted for BEd course in the Bihupuriya PGT Training College, Lakhimpur, Assam in the session 96-97, that is before the initiation of regulatory functions by the ERC NCT Bhubaneswar. Therefore, the committee has
Reading this.
my lord,
125.
124, my lord.
124, yes.
Yes. Serial number 24, my lord.
Yes.
And my notice of pending starts from 114, my lord.
Yeah, that is the ERC has considered matter in front of,
Therefore, the committee has decided to refer the matter to the Secretary, Department of Education, Court of Assam, to the register to the concerned affiliating body to which the institution was affiliated in the year 96-97, along with the copy of the High Court order dated 3/12/2020 in WPC number 2056 of 2020 to inform the recognition status of the BEd course being conducted by the institution in the year 96-97 to the petitioner under the intimation to the ERC NCT Bhubaneswar. Thereafter, government have decided that issue, my lord, and held that his degree is not a valid degree. Page, my lord, 129, my lord. Relevant para is page 130, my lord, last paragraph, my lord. 130, my lord.
Yes.
Considering the matter in its entirety and taking into consideration the report of the TSC Assam submitted by letter number so and so dated 2/1/2020 and memo number so and so dated 15/5/2020 and recommendation of the State Selection Board. The report submitted by the ERC NCT dated 23/2/2021 minutes of 289th meeting of the ERC held on 15/2/2021. Affidavit submitted by the Regional Director ERC NCT before the Honorable Guwahati High Court and materials and record. It appears that the writ petitioner was a BEd student during session of 96-97 and he failed in the regular BEd examination held in the year 1997 and passed the examination early on 27/2/1999, and the Bihupuriya PGT College, Lakhimpur was not recognized during the year 96-97 until the year 2001 under the ERC NCT. And the claim of the writ petitioner regarding validity of BEd degree of Biren Suikia is not correct, which implies that BEd degree is invalid as per NCT Act of 1995. That is the decision of the government methods.
एक साल के अंदर क्या वेरी गुड if not गवर्नमेंट ने ओपिनियन किया कि बाद में अल्टीमेटली रिकॉग्निशन मतलब 2001 में फॉलो फॉलो उसमें जो था वैलिडिटी पीरियड डेड है ये अठारह सौ शिक्षा महाविद्यालय अठारह सौ दे दो 2012 classes no la sé de por una vayan en the bank to the more momento de que te ahí con đó rồi itu sih ulah dulu gitu itu bangsa ulah dulu dari itu bangsa ada suatu tahu ada dua tahu mulai rasa ada satu dulu itu Supreme Court में legal है Supreme Court है क्या है तेरे को नहीं कर बोलो Supreme Court नहीं ना legal नहीं मिला ना हाँ हाँ अरे हाँ बताइए ऐसे कैसे ऐसे It happened. It was the payment. I get. I don't know about the. Hello, sir. No, no, I got a one thousand. I got a new. I got a problem. Suppose I got two thousand. I problem. It is one. It is one. Yes, sir. Understood, no? Huh? Hello. Dustbin आता है जो बन लीगल है तो मुझे बता था कि बोले इसे मुझे क्या कर लोगों ने तो
When was the second application made by the college? Is there any date on that? That must have been before August 1999.
Yes, my lord.
August 99 was the extended date.
Page 307, my lord.
That is a representation, not an application per se. But they have answered the queries made by the NCT. Before that is a page 307.
No, 1997, the application was rejected. They were advised to make a fresh application.
There is nothing on record or not in place by any of the parties. However, there is at page 307 a representation made by the Bipura PCT College referring to the original application, answering the queries made by the NCT. And lordship in the recognition was given even with the same application, the code number given to the application.
Where is that?
That is page 311, Lord. 309, Lord. 309.
You are appearing for?
I'm appearing for the private respondent, number 7. And the recognition was given in
309.
Lordship, that is a process. After in 1998, that is for the year 98, 99, Lordship. And subsequently, one was at one space on 270, Lordship, that was for 99, 2000. This is for the year 98, 99, Lordship, at page 309.
They were allowed to continue. They were allowed to continue.
Lordship, we continue. The college was allowed to continue. Even 270, page number 270, Lordship, that is for the year 99, 2000. It continued from 1996, 97.
Ultimately, it was there. They have to continue.
And Lordship, the code number is similar. What was been,
Oh, you should have shown that first,
Lordship,
that the college was allowed to continue.
Lordship.
Right, Lord.
Lordship, I would like to place 2-3 judgment, Lordship.
Yeah.
Today, Lordship, I have only one, Lordship. I will supply it before, Lordship. Lordship, may kindly take note of my written argument at page 332. I have also quoted the judgment, Lordship. 332.
Yes.
Lordship, 335. Lordship, I am relying upon 2013 2 SSC 617 Maha Vaishno Devi Mahavidyalaya, wherein it has been held that in case of a conflict, University Act will become unenforceable and Central Act will prevail as held by the Honorable Supreme Court. The Supreme Court in the said case has recognized the primacy of the NCT in maintenance of standard of education of teachers ahead of the state and universities. Furthermore, since NCT was formed under the NCT Act 1993, a special law made by the Parliament, the court declared the NCT's authority will prevail in professional education of teachers, including teachers training program. Here, Lordship, the Tribunal University had no authority to give a recognition, and NCT has no role unless, Lordship, the college has come under its jurisdiction. In 1996, the college was not under its jurisdiction, and it was the university, Tribunal University, who had granted the degree, Lordship. Then, Lordship, may kindly come to next 338, Lordship. I've just given a quotation, Lordship. I am relying upon 2012 2 SSC 425, others of Shikshan Mahavidyalaya and others versus Subhas Rangdale. I am relying upon paragraph 16, 17, 17A, 67, 69, and 88. Here in this case, Lordship, when similar matter came up for consideration, the Honorable Supreme Court, quoting several sections of the NCT Act, including section 14, 16, and 17, has held that once the recognition is withdrawn under section 17(1), the institution concerned is required to discontinue the course or training in teachers' education, and the examining body is obliged to cancel the affiliation. No institution shall. I'm just placing one there. I have only one copy.
Mr. Das, what are you arguing? The regional director has allowed the Bihupuri institution to continue.
Continue-
Has anybody challenged that order?
No,
What are you arguing?
no, the
It's not an
subsequently it was done
argument.
that, but when the respondent
no,
Sven
you-
was studying.
You don't argue matters before the division bench like this. When the authority has allowed the institution to continue, you have not challenged. You are saying they should not have allowed. What kind of argument
Lordship
is this?
continued only in 1999, but before that, Lordship, their recognition was cancelled, rejected.
98, 99, they were
Lordship.
allowed.
And he was a student of 1996, and he failed in the examination in 1996. Rejections are the NCT has itself rejected the case, Lordship.
We'll consider.
And Lordship may kindly consider one aspect, Lordship, because I do not have any fault. I am a regularly selected candidate, Lordship. I have been appointed as a regular principal and I am working for the last 4 years in the institution. I may not be disturbed, Lordship.
So what the learned single judge has held.
Lordship, that matter has been remanded back to the DSC Assam for a fresh consideration.
Regard his claim of appointment regular principal. In doing so, the respondent has already appointed regular principal due to the receipt may be arrived at. After hearing you, the decision will be taken. What's wrong in that?
Oh.
Pass it off.
Party appearance.
Supplementary list for admission, item 26 and 27.
But if these two matters kindly be taken up $2.
Yes.
This two, item 26 and 27, kindly take up at $2. Yesterday we mentioned,
So the list is already finished.
no, yesterday we have expressed some difficulties on the.
So we'll take up this matter. What's the problem in?
No,
There are other matters also.
the learned AG is appearing in the matter. He has expressed some difficulty on his part in the first half. Kindly accommodate. Yesterday,
3 years, what we, 3 years, what we will do?
No.
There's no other matter. You know.
we expressed the difficulty.
Only
Yes.
3 matters that we few matters.
Last statement. Last statement. We'll take it as last.
We'll take it as a last item.
We expressed the difficulty yesterday also. It was in the list yesterday, Malad. Kindly.
We have already said on the last, yesterday also we made it clear. Whenever this case will be called, you argue the matter.
So that.
Oh, no, this is not.
Last item. Logic. Good.
Call the AG is going back. Yes.
Item 28.
May it please. I am only trying to enforce the policy of the bank.
Whatever it may be, approach the bank. That's
No,
all.
no, Lordship will kindly give you 5 minutes time, my lord.
Yeah.
If your Lordship will kindly come to page 72.
Yes.
Page 72. This is the OTS policy of the bank, my lord. Now, my lord, we applied for OTS. It was rejected. Kindly see, my lord, the order of rejection.
71.
Page 71.
That you have not offered any amount.
No, my lord, there is a requirement of fixing the benchmark amount. Unless they do, how do I find out what is 10%? Well, kindly see page number 71.
Yes.
With reference to the caption subject regarding your letter received on so-and-so, we are unable to process your request for OTS settlement since no OTS amount and repayment period for the payment of the OTS is not mentioned in the letter. Now, my lord, please come to the policy of the bank.
Yes.
Please come to, my lord, page number 82. No. Benchmark amount. Benchmark. No. Sorry, benchmark amount. Yes. Page 83, my lord. The settlement amount to be at least equal to the benchmark amount as per the policy should preferably be paid in lump sum within 90 days. Now, this benchmark amount, lordships will get
That's it, 95.
95, my lord. Now, page 95. Minimum recoverable amount, net present value of the security, net present value of the settlement amount, benchmark are higher of 1 and 2. So unless they identify, they say, my lord, how do I measure the 10% and 50%? Then please come to page 96. Upfront down payment. Party has to deposit upfront payment to show seriousness in settlement of OTS proposal. The upfront amount may be kept in escrow so-and-so with mandate to appropriately proceed towards the adjustment of the due. Upfront amount will be taken as follows: 10% of the amount to be deposited at the time of submission of OTS proposal. Then, my lord, 2, we are prepared to do that. 15% of the OTS amount has to be deposited within 30 days of the receipt of the intimation. Then, my lord, will kindly come to 97. The 10% amount deposited by the party at the time of submission of OTS, thus making the total of 50%, and rest within 90 days.
107.
And page number 107, my lord.
Yes, on our case, recovery certificate.
Now, even if there is a recovery certificate, this is the provision, my lord. Page 107. In case of recovery certificate of DRT, there are 2 options available in the above cases to the bank looking to the practice of DRT. A joint petition before recovery officer narrating the facts and compromise of the compromise settlement with a prayer to postpone the execution proceeding till realization of the due should be moved. So look, these are the provisions the bank itself has provided. That there is a decree. In spite of decree, there is all that we are saying is, my lord, let them fix the benchmark amount. We cannot fix it. Then, my lord, will immediately approach.
The DRT.
No, DRT we have gone. There is a certificate.
No, we are not gone DRT against this.
So we have filed an IA, my lord.
E-auction notice, you have not approached the DRT.
No, no.
Instead, your some cousins have approached the DRT, and now
No.
their application has now been dismissed. Now immediately, this stay order was granted in the year 2000.
No, but my humble.
Till date, you have not
No,
made
lordship.
any application
No,
for
lordship
that.
will, no.
Even you were party before the DRT, you chose not to appear before the DRT.
No, we appeared, my lord. We filed application.
No, you not appeared. You not appeared.
Yes, we have filed the IA, my lord.
No one has appeared, sir.
Page 26.
Yes, no,
The impugned order.
No, my lord, page 26.
The impugned order, sir.
No, it has been shown. Please come to page 29, my lord.
Come to this order, sir, please.
My lord,
First
an
of all,
interlocutory application filed for modification, alteration of order dated 4/9/23 and
sir,
19/10/23.
please come to page 54.
Yes, yes, they have shown as none appears, but they have appeared, my lord.
Where?
So, my lord,
Even
all
though
that.
some other persons have approached this court by way of filing petition, where the court has granted liberty to approach to the DRT,
Yes,
and thereafter, that person has approached the DRT, that application was pending, status quo order was there,
yes.
some violation was also there,
Yes.
ultimately that was
No,
withdrawn.
my lord.
But you chose not to appear before the DRT, despite being party, no offer on behalf of the petitioners at any point of time that we are ready for
26
settlement. Nothing.
Kindly see, my lord. Kindly come to page 26, my
Yeah,
lord.
whatever it is, ultimately, sir, it's in surface matter. The Supreme Court has clearly held that you are not supposed to do all this.
So, my lord will kindly come to page 29, my lord.
Yes.
Now, page 29, it starts. If a lordship would kindly come to page 34, the prayer. In the premises aforesaid, your lordships would humbly pray that they would be pleased to admit this evidence, modify the order, and further direct the respondent authority to provide OTS policy as per the guidelines upon cause or causes being shown, and after hearing the respective parties, honorable court may be pleased to make the rule absolute. So we approach them, my lord. No, lordship will kindly see there was a loan of, my lord, 35 lakhs, 18 lakhs we have repaid, 17 lakhs remained. Now we are entitled to a consideration of an OTS. Now bank has refused on the ground that we have not paid 10% and we have not indicated the, my lord, repayment period. Now, my lord, unless the benchmark amount is fixed by the bank, how do we determine that 10% or 15%? That's why I'm saying, my lord, we'll approach the bank. My lord, by tomorrow we'll approach.
With 10%.
With 10% proposal, let them consider it, my lord.
Any point of time, you may approach.
No, my lord, the question is, my lord, there is an order hovering over us. That's the problem. So, Lord, will kindly see, all that we are saying is, Lordship would kindly come to page 108 for a moment, my lord,
Mr.
where our right of consideration is there.
Not at all, we are not going to entertain this petition. We suggest you withdraw it, we grant you a liberty to approach the bank. The bank will consider strictly in accordance with law. That's all.
According to the proposal, sorry, policy.
Strictly in accordance with law. If the policy is as per law, they are supposed to consider.
Okay, my. Only thing is, my lord, e-auction is fixed on 25th. They will defer that, my lord, for some time.
Sir, we are not granting any indulgence, please. In these matters, not. This petition is filed by the petitioner essentially being agreed with the e-auction notice dated 3/4/2024. Whereby the property in question is put to auction by the respondent bank. Full stop. After attempting to the matter on merits for quite some time, then it consent from the petitioner on instructions as submitted that he wants to the petitioners want to withdraw this petition with liberty to approach the respondent bank for considering their request to
apply for OTS.
Apply for OTS scheme in accordance with law.
As per the policy dated 9/5/22, my lord.
Sir, whatever the policy in vogue,
Yes.
so 22, 24, whatever the policy, you apply to that.
And they will consider in accordance with law.
Liberty as prayed for.
And the bank will consider it, my lord.
Now, obviously, if you file, certainly they'll consider it. We are not going to pass it.
In some cases, lordship will make some exception, my lord.
Yes, in some cases, the hardship, we have made the exception in some of the cases, but not in these cases.
Daily list for hearing, item 9 to 11.
May it please the Lord. This is a appeal preferred by the state of Assam Lordship against the order passed by the learned single judge at the interim stage. The basic issue which we are urging before this honorable court is, Lordship, whether a writ under 226 is applicable in respect of issues relating to appointment and recommendation to IS selection. So that is the issue. If Lordship is pleased to look at the various orders prior to passing of the final interim order. Page 158 is the second order. There is another order at page 160. 160 there, out. At page 136. Order from here. 18 to 2018.
Second order.
The petitioner is an association of Assam civil officers and they were concerned with the proposed upgradation to the IS cadres of respondent number 8 to 17. The upgradation to the IS cadre is governed by the Indian Administrative Service Appointment by Promotion Regulations 1955. And the learned senior counsel refers to the fact that the private respondents are not holding post equivalent to the post of deputy collectors in the state civil service as required under Rule 413 of the IAS Appointment by Selection Regulation 1997. The senior counsel refers to the DPC proceedings of 18/9/2017, whereby 10 officers were recommended for upgradation to the IS and the subsequent notification 27/10/2017, whereby the concerned posts were declared to be equivalent to the post of deputy collectors in the state civil services. The petitioner contends that equivalence to the post has to be notified first in accordance with Assam Civil Service Rule 1998 and the post of Superintendent of Taxes, Deputy Register of Cooperative Societies, Technical Officers, Research Officers, etc. mentioned in the later notification of 27/10/2017 are not shown as equivalent post in the Schedule 1 of the Civil Service Rules. It is further averred in paragraph 12 in pursuant of the recommendation of the DPC, the UPSC has included Manjula Soikia Bhuya and Rakesh Agarwala in the final select list for upgradation and same is now awaiting approval of the central government. The council submits that the concerned two incumbents had not served 8 years of equivalent post and therefore they are entitled for upgradation to the IS cadres. In view of above, let notice returnable in 4 weeks be issued. The petitioner to ensure service of the UPSC, last paragraph, in the interim upgradation of the private respondents to the IS should not be made if the equivalent to the post declared later under the notification of 27/10/2017. This order was passed on 28th of February 2018. Prior to that, Lordship, they were already appointed 19th of February 2018. From the state government side, Lordship, while this petition was filed, page 158. The first order was of 28th of February, now 28th of March order. The respondent number 9 has filed the IA to recall the interim order dated 28/2/2018. The High Court under this order state the upgradation of the private respondent 8 to 17 who are non-state civil service officers to the IS cadre. The applicant counsel also this so-and-so projects that the matter pertains to upgradation to the IS and the appropriate forum is the Central Administrative Tribunal and accordingly the jurisdiction of the High Court is questioned by the applicant. Then the petitioner side counsel submitted that the Honorable Court is competent to deal with the present matter. And the Honorable Court was pleased to continue the interim order. So till this moment, we did not respond regarding the on merit. We have raised a preliminary objection. Thereafter, on 26th of April 2018, the Honorable Court, by narrating everything, was pleased to take into consideration. In fact, Lordship will kindly come to page 163. What is our as well as the other respondents stand before the learned single judge. Paragraph 7.1. The petitioner side's narrative is basically on the merit. 7.1 says, on the other hand, Mr. N. Dr. the learned senior counsel appearing for the respondent number 9 submits that the jurisdiction of the High Court is excluded in matters relating to the recruitment to all India services, and he refers to section 14 of the Indian Administrative Tribunal Act 1985 to project that the appropriate forum for the aggrieved party is the Central Administrative Tribunal and not the writ court. The council cites L. Chandra Kumar's case, and in particular paragraph 93 and 99 of the judgment to content that in matters relating to recruitment to the IS, it is not open to the litigants to directly approach the High Court by ignoring the cap. And in cases like this, the tribunal is the court of first instance for the aggrieved party. He relies on the court's judgment in Tajuk Charo's case of 2015 1 GLT 588 to argue that the CAT is the competent forum for this case. The learned senior counsel D, thus representing the respondent 8, also basically has the same thing, and paragraph 9, the state government stand representing the state authorities, so and so adopts the argument of senior counsel N. Doctor, who appears for 9. So this was our stand till this moment, that this is not the right forum for adjudicating the list. However, the learned single judge not only considered the whole matter, holding that regarding the maintainability under 226 is acceptable, and also opine and give clear-cut findings on merit also. So that has aggrieved us. We are aggrieved on two folds. One is that maintainability part. The other part is without giving us an opportunity of responding to the contention and allegations against the state government. On merit, Lordship, the Honorable Court was pleased to pass the order, and finally the Honorable Court ordered that we can still file the affidavit. If Lordship is pleased to come to page 173, paragraph 33. Following the above interim conclusions, as the counter affidavit is yet to be filed by the state, the Assam government should now explain what prompted them to act in the manner they did. The state must disclose how the concerned incumbents in the non-SCS group, as assessed to be the special category of outstanding merit and ability in comparison with other non-SCS officers who deserve entry to the IS, although they were not holding the equivalent level post of deputy collector in the state civil service. The reason why the notification dated 27/10/2017, Annexure 7, was never circulated or gazetted must also be disclosed. How the equivalence declaration can retrospectively satisfy the eligibility requirement of 8 years continuous service as deputy collector should also be explained by the state. These and other facets of the challenge should be responded through a counter affidavit in next 4 weeks. But immediately we came before this honorable court at that point of time, and it was late. Now, the findings of the learned single judge. If Lordship is pleased to come to page 163, the discussion and decision. Here I am skipping paragraph 13, Lordship will kindly come page 165. This is a part of the findings and discussion. The names, the 15 names shortlisted from the non-SCS category in pursuant to the notice dated 28/2/2017. This is the first communication issued by the state authority various departments to forward the deserving candidates who can be considered. So the process started here regarding recommendation for the nomination to IAS. So 28/2/2017, this is the first letter. The names shortlisted from non-SCS category in pursuant to the notice dated 28/2/2017, page number 2, were considered by the selection committee in their meeting held on 18/9/2017. Out of the shortlisted 15 names, 10 officers belong to the non-SCS category were recommended by the selection committee, and the same was then required to be considered by the UPSC. But what is of significance is this recommendation is neither on 1/1/2006, that is relevant date when the 2 vacancies of IAS for non-SCS categories were available, or when the pro forma was circulated on 28/2/2017. An extra 5%. Page 68. Or on the date when the selection committee made their recommendation on 18/9/2017. The recommended incumbents were holding any post equivalent to the post of deputy collectors of state civil services. Therefore, it is apparent that the recommended candidates were ineligible for consideration for appointment to the IAS under the applicable norms. This is a finding of the learned single judge. Now, why I am trying to give stress on 28/2/2017, Lordship would kindly come to page 68. This 28/2/2017, this was issued by the Secretary to the Government of Assam, Personnel A Department. This request was given to all the additional chief secretaries of the state of Assam, all principal secretaries of Government of Assam, all commissioner and secretaries of the Government of Assam in various departments, about 41 or 42 departments. Subject: appointment of non-SCS officer to IAS by selection during the select year 2016. With reference to the above, I am directed to state that in accordance with the Regulation 4 of the IAS Appointment of Selection Regulation 1997, the state government proposes to consider cases of non-SCS officers of the state government for appointment to the IAS by selection. The officer to be considered should satisfy the following conditions. The officer should be of outstanding merit and ability. The officer should hold a gazette post in a substantive capacity. The officer should be completed not less than 8 years, etc. And 4, the officer should not be below 56 years of age as on 1/1/2016.
Mr. Parekh, these are all merits. We are not.
No, I'm saying when the process for appointment of non-SCS officers to IAS by selection during the year 2016, that is how this particular event of recommendation and selection falls under section 14 of the Central Administrative Tribunal Act. That is what the Honorable Supreme Court held, as well as by the learned single judge in another case of this Honorable Court held. So the process started from this date. All these are subsequent events. What is the subsequent event? The selection of in the month, the shortlisting of the candidates in the month of September, then the issuance of the notification in the month of October, then the central government's selection on 21st of December 2017, another, that is the actual selection by UPSC. Finally, by appointment given on 19th of February. All these comes under the purview of selection and appointment of non-SCS officers. So they come under the realm of the CAT Act of 1985.
One clarification, you are not questioning the maintainability of the writ petition on the ground that the individuals affected officers are not before the court. It is an association. This being a service matter, the association cannot. That's not your ground.
Our case is that they can go there and we will fight it out if we have done anything wrong. The forum, we are only on the forum, not on merit. We'll justify. The learned single judge, while giving those opinions, never heard our side, or we have not expressed our side. Our side is still open.
But ultimately, the learned single judge in its order has simply directed you to explain in what manner you are.
We'll definitely explain, but whether we should explain before this honorable court or before the tribunal.
That's the only question.
That is the only question. If it is tribunal, then we get another forum here, number 1. And number 2, it is in direct violation of the Constitution bench judgment. The learned single judge opinion of holding this maintainable is in the direct conflict with a single judge's order, as well as a judgment of the Honorable Supreme Court passed by a Constitution bench. So this is my case, not on merit, absolutely not on merit. That is why I'm giving importance to this letter of 28th February, because the motion started with the issuance of this letter, when the process was started, initiated. Whether that notification was subsequent to the selection, prior to selection, all these things will handle lordship. And the selection, what was done in the month of September, it was a shortlisting. When all the names came from this department, it was shortlisted by the state authority and it was forwarded. The selection was done by the UPSC's authority. There is a different selection committee under the Act and under the statutory norms. That was held in the month of December. So my humble submission is that the facts started from this. This is the starting point at 28th February 2017. So in that situation, I want to cut short because the other things are all factual, the learned single judge's findings, etc. Now, the learned single judge's opinion regarding the maintainability also. Paragraph 14 is also on merit. 15 is on merit. Paragraph 16, there is a directly incorrect findings. Paragraph 16 says, viewed page 166. Viewed in the above context, the subsequent notification of 27/10/2017 does appear to be clumsy attempt by the state to fill up the legal lacuna and to confer a semblance of legitimacy. For the respondent number 8 and 9, although it is apparent that they have never served as 8 years in an equivalent post of deputy collector on the date of selection, that is 18/7/2017. 18/7/2000 selection date is not the date of selection. The date of selection was in the month of December. This was the shortlisting date, number one. And number two, all these incumbents, they completed 8 years service way back about 10 years or 15 years ago.
This, so far as regarding maintainability part is concerned, that starts from para 18.
Yes, Lord. Not 18. It starts from paragraph 18, yes.
Yes.
Up to merit, up to paragraph 17. May I read it, Lordship? Now, maintainability point. Let us now examine whether the writ court should entertain this case and whether the CAT is the only forum available for the aggrieved party. In L. Chandra's case, the Supreme Court, even while declaring that the tribunal will act as the court of first instance in respect of areas of law for which they have been constituted, unequivocally declared that the tribunals cannot act as a substitute for the High Court or the Supreme Court. It is also held that the power of judicial review over legislative action is an integral and essential feature of the Constitution. On the issue of appropriate forum, it will be a repetition that the key challenge here is to the equivalence declaration to post held by the private respondents to the impugn notification dated 27/10/2017. If this is the only case, if it is the only prayer that they are challenging 27/10/2017's notification, I have no case at all. I would not have filed the appeal also. We would have filed appropriate affidavit and fought it out before the learned single judge in the writ court. But their challenge was not only 27/10/2017. Their challenge is something more. The post of superintendent of taxes held by the respondent number 9 is governed by the Assam taxation rules, and the Assam Industrial Service Rules covers the post of Joint Director of Industries held by the respondent number 8. As can be seen, the posts which are equivalent to a post in any cadre are included in Schedule 1 of the Assam Civil Service Rules 1998, and it is apparent that the two posts of non-SCS category, where the respondent number 8 and 9 have served, are not declared to be equivalent to the post of Deputy Collector in exercise of the power under Rule 3.3 of the Assam Civil Service Rules 1998. The concerned civil service rules covering those posts held by the respondents were made in exercise of the power conferred by the proviso to Article 309 of the Constitution of India, and undoubtedly they are in the domain of legislative function of the state. Therefore, if any changes is to be made to the concerned service rules, the role of the state will surely be legislative in character. Logically, therefore, even under the ratio of L. Chandra Kumar's, the power of judicial review vested in the High Court under Article 226 of the Constitution over legislative action of the state cannot, in my considered assessment, be outstayed in this matter. Adding one more line of argument here, the Honorable Court held that this is an exercise of legislature. If that be the case, then the division bench is the appropriate forum, not the learned single judge, according to our High Court rules. Going further now, sticking to the issue of jurisdiction, it is also necessary to point out that a jurisdictional fact must exist before a tribunal or an authority assumes jurisdiction over a particular matter. When we examine the state action from this perspective, the jurisdiction of the writ court is not outstayed, and for such conclusion, this court can draw support from the ratio of Arun Kumar versus so-and-so reported in so-and-so, where the Supreme Court declared as under. A jurisdictional fact is a fact which must exist before a court, tribunal, or an authority assumes jurisdiction over a particular matter. A jurisdictional fact is one on existence or non-existence on which depends the jurisdiction of a court, a tribunal, or an authority. It is the fact upon which an administrative agency's power to act depends. If the jurisdictional fact does not exist, the court, authority, or officer cannot act. If a court or authority wrongly assumes the existence of such fact, the order can be questioned by a writ of certiorari. The underlying principle is that an erroneously assuming existence of such jurisdictional fact, no authority can confer upon itself jurisdictional which is otherwise does not possess. In Halsbury's Lordship, this, in my humble submission, is not very relevant also. Paragraph 21. The adjudication on dispute which arises out of exercise by the power by the state in the legislative domain relating to changes in the service rules frames under the proviso to Article 309 should best be declared by the High Court, decided by the High Court. So the learned single judge held that this should be decided by the High Court because there is a change and there is a angle of legislative exercise. If that be the case again, it will come to the division bench. Even in matters pertaining to recruitment to All India service where the Central Administrative Tribunal is otherwise competent to exercise jurisdiction under Section 14 of the Tribunal Act of 1985, the assumption of jurisdiction by the tribunal will have to be preceded by certain acts to be done by the state government. If those very acts of the state government in the domain of legislative function bring an undeserving non-SCS incumbent to the arena of the recruitment to the All India service and aggrieved party challenges the state action, the writ court, in my considered opinion, should surely be the better forum to adjudicate the issue. So my humble submission is that what the learned single judge indicated here, that by the notification of 27th October 2017, the equivalency has been granted. And according to the learned single judge, it is an exercise of legislative nature. That is amounting to an amendment of the existing service rules. If that notification is considered to be a legislative action, then it will again govern by our High Court rules and it has to be tested in a division bench of the Honorable Court. Then also it is not maintainable. So the learned single judge finding here that if those acts of the state government in the domain of legislative function.
Mr. Secretary, just interrupting you. You are saying that even if it is to be heard by a division bench, then also writ petition will not be maintainable.
Absolutely not. It will be maintainable before a division bench, not before a single judge.
So writ petition will be maintainable.
If, because we are not saying this is a legislative action.
Right.
If we had amended the 309 rules, now why the Honorable Court has saying that? The learned single judge found and decided and come to the conclusion that the state service rules must include this post. This post, how can it be there in the civil services post?
No,
They are governed by
just a
two
minute.
different rules.
Just a minute. We are trying to understand your argument.
Lordship.
One limb of your argument is that the High Court could not have even touched this petition.
Yes.
And referred the matter to the CAT because of the mandate of L. Chandra Kumar. That's one limb of your argument.
Yes.
Second limb is even assuming that the tentative interpretation of the single judge is correct, that this transgresses into a legislative field. And therefore the CAT would not have the jurisdiction to.
Lordship.
Even then, this matter ought to have been heard by the division bench.
Absolutely.
But here it is not that writ petition will not be maintainable. It is that the matter will have to be heard by the division bench.
Absolutely.
So do you agree there is a distinction between the two?
I fully agree because this is the finding, this is the expansion of what was argued by before the learned single judge. It was never argued in that line. Neither of the side argued that this is a
All we are
action.
pointing out is that in the first case, writ will not be maintainable.
Absolutely.
In the second case, writ will be maintainable, but the forum to hear would be a division
If
bench.
it is considered to be a legislative function.
Right. So that is not there.
That was never argued also. It was not argued. Nothing. So, and my third submission is that if it is a only challenge of 27th October's notification, then it is maintainable. There is no doubt about that. But their challenge is not there. If Lordship is pleased to look at their prayer in the repetition, page 42.
Where is this 2710?
27th, I'll just. Page 72. This is an administrative order, Lordship. It was under Article 162, not under 309. Page 72, October 27, 2017. For the purpose of appointment of non-SCS officers to IS, the following posts under the respective departments as mentioned against the post are declared to be equivalent to the rank of Deputy Collector of the State Civil Services. So these are the posts which are the equivalency, and it was issued by the Personnel Department. They are connected. Personnel Department is connected with all the administrative departments. So if it is a challenge only regarding this, then repetition is maintainable. If Lordship is pleased to come to page 42. They have the prayers.
So today, except the equivalence, what else is the live issue? There is nothing else. So if the challenge is confined to
yes
27 October,
that was my first day's opinion.
That is yours. That is the purpose.
Yes, my lord,
Nothing else survives.
My lord,
But Lordship will, they have to give up the other prayers. The other prayers they did not give up last time. They sought instruction, and after their instruction came, they said we are still holding that their all past benefits should be taken away. This was their
my lord,
submission.
everything cannot happen as my learned friend would like to dictate. Let us make it very clear, my lord.
I am not dictating
My lord,
anybody.
before the learned single judge, what view we take after lawsuit remand, that is for us. How can everything be prejudged in a writ appeal that too against an interim order?
No, Mr. Chaudhary, see, you argue, let's take the.
My lord,
1
as
minute.
superintendent of tax was made equivalent to a deputy collector. And I'm just indicating, my lord. Kindly see, my lord, the extent of arbitrariness in the decision-making process. Please come to page number 135 for a moment, my lord. 135 of the other appeal, 165. I read appeal 165 to the option. There is a limit of, my lord, favoring somebody, my lord. Some blue-eyed boys. Kindly have page 135.
You're referring to writ appeal number 167.
165.
Page
135. We have given a chart, my lord. My lord, an ACS junior grade officer, his grade pay is 13,300. He is the lowest, my lord. When he joins, either he is a circle officer or an executive magistrate or an election officer. Kindly see, my lord, the superintendent of tax. His grade pay is 12,700. My lord, this ACS junior cadre officer to become, my lord, ACS grade 2, then his, my lord, grade pay will be 15,100. It is at that stage, my lord, he becomes equivalent to deputy collector. Now, to show favor to this gentleman, my lord, Now the superintendent of tax, a person on 1/1/2008, he was a superintendent of tax by his own showing. And he is sought to be made. Now, my lord, on the maintainability point, the learned single judge has decided, para 19 is very clear.
No,
Sing-
Mr. Chaudhary, he is yet to conclude. We are
Yes.
on a very short point.
Hmm.
If it is not necessary to go into certain
Exactly,
areas,
exactly.
we don't want to. Except for the equivalence, we can understand
Yes.
your clients may have a grievance about the equivalence. The rest of the things, all these two officers have already retired from service.
Yes.
Right.
But they have got some unintended benefit. We would say, my lord, we would respectfully argue that their appointment should be, nomination to the IS should be cancelled.
Is that your
Some-
prayer?
Yes,
That is-
we'll do
that
that before, when the matter goes to the learned single judge.
No, no.
We'll do, no, my lord, kindly see by a stay order, the matter is stalled here. We have no opportunity to go to the learned single judge. If your lordship today holds that no, the writ petition is maintainable, we'll take all of our consequential, steps, my lord, legal steps. Now, my lord, what is the issue? My learned friend has made 3 submissions. According to the second and third, either the writ petition lies before the division bench, and if the challenge is confined to 2010, then the writ petition lies even before the learned single judge. Just now he has made that submission. Now, what else we are making? Please come to the impugned judgment. The learned single judge dealt with that only, my lord. Learned single judge dealt with that equivalence notification only. My lord, when we approach this honorable court, we are basically aggrieved by that equivalence notification.
So Mr. Chaudhary and Mr. Saike and Mr. Das, subject to what my lord, the Honorable Chief Justice may opine, there are 2 things here.
Yes.
Except for equivalence, nothing else is live.
Yes.
How we draft an order is our business.
Yes.
But nothing else is live. Secondly, these findings are tentative, cannot influence the final outcome of the
Of
proceeding.
course.
Beyond that, what else is there to be decided?
Nothing,
in this
nothing.
case? That's all we are asking you.
But my lord, I'm sorry to interfere. My lord, if Lucas, your lordship has put a query to my learned friend. The Lucas has been challenged or not? We have challenged. Lucas, we have challenged. These are the associations.
That is to be decided by the single
No, no,
judge.
Yes.
Lucas, we said, what is the maintainability on the point of Lucas we have challenged before the learned single judge. H2, that's the point your lordship has, that's the point your lordship
The
has
writ
made.
petition has not been admitted.
But in finding,
No.
finding my
we'll
lord,
expunge
to
the
such a
findings.
certain extent,
These are tentative findings.
whatever my lord, we are challenging the maintainability of the writ petition.
That will remain open.
The writ petition, we are challenging the maintainability.
That will remain open before the single.
Everything, yes.
Everything, lordship, there I have the problem because they have to give up prayer number 1, 2, and 3. Only 4 prayer, I am agreeing.
1, 2, and 3 are the prayer.
They are challenging the selection, or that is actually the shortlisting of 18/9/2017. And the whole process, prayer number 1.
Mr. Sekia, you can very well raise this point before the learned single judge.
No, if that is allowed, that is my then.
These 3 prayers now cannot be granted. You can
It
very
may
well
not be
ask
granted,
for the-
but whether a learned single judge can enter into this domain, that is why I want to place the judgments.
That is not the learned single judge to.
No, the
consider
learned
it.
single judge has already said it is maintainable.
That's the only point which we are supposed to decide here, whether this rate is maintainable or not. That is
This
the
writ,
only-
if it is, if the writ is
because
maintainable,
we don't want to enter into the merits of the case.
I fully
We don't
agree.
want to enter.
But if it is maintainable, then the whole law will be against the, in conflict with the Supreme Court judgment.
That will take care of that, sir.
No, then let me complete my submissions.
Why are jumping to the conclusion that we are going to hold
No, if
that
it- no.
is maintainable? We can take, we can decide.
I have
otherwise
not, I have not opened up all my cards also.
So the only point which we are going to consider is.
I am
whether-
considering,
whether-
if they consider
whether
prayer
the
1, 2, and 3.
petition is maintainable before the learned single judge or not. Now, what relief they are claiming and what relief can be granted, it is for the learned single judge to decide.
No, may I just submit, lordship? If it is sent back to the learned single judge to decide on the maintainability, which was already decided,
Not on maintainability.
It was decided on maintainability.
Sir.
Maintainability, it was decided.
Until and unless it decides that it is maintainable before the learned single judge, how can we remand? Maintainability question is already decided.
Already decided.
Now we have to consider whether that question is rightly decided or not. This is what the matter is pending before the.
No,
division
whether
bench.
the learned single judge can overrule another learned single judge's order.
So that we will decide. You argue it out on this point.
No, okay, let me argue.
Only regarding the maintainability.
Only I'm on that. I'm married. My learned friend is agitating. I am not agitating married.
No, that is.
Yes.
Let no one agitate.
My learned friend gets hyperactive sometimes. It is acceptable. No
my
problem with that.
This is not acceptable. Whether I get hyper, I don't want any certificate from anyone.
I'm not
Mr.
giving
Chaudhary,
certificate,
let
but
my
I
learned
am at the
confine his
receiving
part
end.
to his.
I am
Let
at the
him not
receiving
make any
end.
comment on my conduct.
Yes, I am on the receiving end, so I have the right to respond.
We all
Whenever I
see
am
every
submitting, always interrupted. Every day. So now, what the, paragraph 23 now. I'm repeating this paragraph. The rule of exclusion of writ jurisdiction due to availability of an alternative remedy is a rule of discretion and not one of compulsion. In an appropriate case, even when an alternative remedy or forum is available, a writ court may exercise its discretionary jurisdiction of judicial review, and three contingencies of such nature are highlighted by the Supreme Court in MP State's case, etc. Taking a cue from this, in cases where the orders or proceedings are wholly without jurisdiction, the writ court intervention, even in matters pertaining to recruitment to all India service cannot automatically be outstated. So here, one issue the learned single judge found that jurisdiction. Here, the state government has decided to confer undue benefit to the non-SCS category incumbents, and the consequential process of recruitment to the IS proceeds only on the basis of state government's decision in the realm of the state's legislative domain. In matter like this, the more appropriate forum, in my understanding, is not the tribunal, but the writ court. So the learned single judge held that notification was issued without jurisdiction. This is the implication of this paragraph.
Other paras are also dealt with the very same question, the 24, 25 and 26.
Yes, Lordship. 26. Now, paragraph 26.
24, 25, 26.
Yes, Lordship, 25. The number of persons to be appointed to IS from the category of non-SCS officers at any time must not exceed 15% of the total persons appointed under Rule 8. Read with proviso to Rule 9(1) of the recruitment rules. In the present case, the total vacancy under Rule 8 from both SCS and non-SCS category is 7, and thus only one post becomes available for the non-SCS category. Since 2 posts of the non-SCS category is made available, the respondent authorities have exceeded its jurisdiction by earmarking more than 1 post to be appointed from the non-SCS category. It is also important to bear in mind that notification dated 27th October 2017 was neither circulated nor gazetted, notwithstanding its far-reaching consequences. The equivalence declaration made by this notification is clearly including into legislative domain, and the respondent number 6, as the Secretary to the Government of Assam, Personnel A Department, had neither the competence nor the authority to announce that the post held by the private respondent should be considered to be equivalent to Deputy Collector's post. In fact, the declaration is construed retrospectively for the private respondents to confer unmerited benefit. This reflects a non-bona fide exercise by the state authorities. These are findings, Lordship, without hearing us, Lordship. I am not going to comment anything except to say that whole thing will change. There will be about turn if we disclose our stand, Lordship, but I am not disclosing those at this stage. The learned senior counsel N. Datta relied upon Tajuk Charus versus Union of India reported in 2015 1 GLT 588 to contend that in a matter pertaining to recommendation of non-SCS officers from Arunachal Pradesh for promotion to IS, the tribunal alone has the jurisdiction, being the court of first instance. But this verdict of the learned single judge, in my opinion, is distinguishable in as much as the eligibility of the respondent belonging to the non-SCS in Tajuk Charus was not in question. Therefore, in the present facts, the ratio of Tajuk Charu will not come in a way of exercise of writ jurisdiction by the High Court. Regarding this paragraph, my submission will be, Lordship, both the cases are on equal factual background. I'll place that judgment also. If the learned single judge in our case is differing from the opinion given in Tajuk Charu's case, Lordship, the appropriate courts would have been to refer it to a larger bench. But that was not done. That is another limb of my argument. Having answered the judicial issue against the respondent, it is necessary now to examine whether the interim order so and so. Now on merit. So this is the finding. Let me now first place L. Chandra's case and thereafter this Tajuk's case, Tajuk Charu's case. And before that, rule section 14.
Administrative.
আসছে নাকি এখন দিতে না?
Administrative.
May I read it, Lordship?
Yeah.
Jurisdiction, power and authority of the tribunals. Section 14. Jurisdiction, power and authority of the Central Administrative Tribunal, save as otherwise expressly provided in this Act. The Central Administrative Tribunal shall exercise on and from the appointed day all the jurisdiction, power and authority exercisable immediately before that day by all courts except by the Supreme Court in relation to number 1, recruitment and matters concerning recruitment to any all India service or to any civil services of the union or a civil post under the union or to a post connected with defense or in the defense services, being in either case a post filled by a civilian. So here it is recruitment and matters concerning recruitment. B, all service matters concerning a member of all India service. Directly it is covered by this. All service matters, including equivalency. A member of any all India service or a person not being in a member of, say, appointed to any civil service of the union or civil service post under the union. 3, a civilian, etc. 3 is not relevant. And pertaining to the service of such member, person or civilian in connection with the affairs of the union or of any state or any local or other authority within the territory of India or under the control of the government or of any corporation or society owned or controlled by the government, all service matters pertaining to service in connection with the affairs of the union, etc., etc. So here, very clearly it has been said that all service matters concerning a member of all India service. and in respect of recruitment and matters concerning recruitment. That is why that 28 February's letter was very important. That recruitment process was started. So whatever comes in course of the exercise of that recruitment process, Section 14 is directly applicable there. And that has been discussed in L. Chandra's case now. In fact, this 5 judges constitution bench dealt with this issue only, nothing else. Starting over the page 269, I'm reading. I am starting from the beginning. The special leave petitions, civil appeals, and writ petitions, which together constitute the present batch of matters before us, owe their origin of separate decisions of different high courts and several.
Yes.
Page 269, Lord, the beginning part. The special leave petitions, civil appeals, and writ petitions, which together constitute the present batch of matters before us, owe their origin to separate decisions of different high courts and several provisions in different enactments, which have been made the subject of challenge. Between them, they raise several distinct questions of law. They have, however, been grouped together as all of them involve the consideration of the following broad issues: whether the power conferred by the Parliament or the state legislatures, as the case may be, by subclause D of clause 2 of Article 323 or by subclause so and so of Article 323B of the Constitution, to totally exclude the jurisdiction of all courts except that of the Supreme Court under Article 136 in respect of disputes and complaints referred to in clause 1 of Article 323A, or with regard to all or any of the matters specified in clause B of Article 323B, runs counter to the power of judicial review conferred on the high courts under Article 226, 227, and on the Supreme Court under Article 32 of the Constitution. Whether the tribunals constituted under Article 323A or under Article 323B of the Constitution possess the competence to test the constitutional validity of statutory provisions, rules, etc. Whether these tribunals, as they are functioning at present, can be said to be effective substitute of the high courts in discharging of the power of judicial review. If not, what are the changes required to make them conform to the founding objectives? We shall confine ourselves to the larger issue raised in these batch of matters without adverting to the specific facts of each of the matters. We shall, however, selectively refer to some of the impugned decisions and the provisions involved to the extent we find it necessary to do so in order to appreciate the policy conflicts in and to draw parameters of the controversy before us. The broad principles enunciated in this judgment will at a later stage be applied by a division bench to resolve the disputes involved in each of the individual cases. Then quoting of paragraph 5, the quoting of the Assam, this section 3, Article 323, tribunals from the Constitution. Now, paragraph 7. In pursuance of the power conferred upon it by clause 1 of Article 323 of the Constitution, Parliament enacted the Administrative Tribunal Act 1985. Herein after the Act, the statement of objection reasons of the Act indicate that it was in the express term of Article 323A of the Constitution and was being enacted because a large number of cases relating to service matters are pending before various courts. It was expected that the setting up of such administrative tribunal to deal exclusively with service matters would go a long way in not only reducing the burden of the various courts and thereby giving them more time to deal with other cases expeditiously, but would also provide to the persons covered by the administrative tribunal speedy relief in respect of their grievances. Paragraph 15. Chapter 3, Jurisdiction, Power and Authority of the Tribunals, consists of section 14 to 18. Section 14, 15, 16 deals with the jurisdiction, power and authority of the Central Administrative Tribunal, the State Administrative Tribunal and the Joint Administrative Tribunal respectively. These provisions make it clear that except for the jurisdiction of this court, the tribunals under the Act will possess the jurisdiction and powers of every other court in the country in respect of all service-related matters. Section 17 provides that the tribunal under the Act will have the same power in respect of contempt as are enjoyed by the high courts. The procedures, etc. Then narration of various cases, submissions, and the Honorable Court finally comes to paragraph 93 now. Paragraph 90 also is important. 90. We may first address the issue of exclusion of the power of judicial review of the high courts. We have already held that in respect of the powers of judicial review, the jurisdiction of the high courts under Article 226 to 27 cannot wholly be excluded. It has been contended that before us that the tribunal should not be allowed to adjudicate upon matters where the virus of legislation is questioned, and that they should restrict themselves to handling of matters where constitutional issues are not raised. We cannot bring ourselves to agree to this proposition, as that may result in splitting up proceedings and may cause unavoidable delay. If such a view were to be adopted, it would open to the litigants to raise constitutional issues, many of which may be quite frivolous, to directly approach the High Court and thus subvert the jurisdiction of the tribunal. Moreover, even in these special branches of law, some areas do involve the consideration of constitutional questions on regular basis. For instance, in service law matters, a large majority of cases involve an interpretation of Article 14, 15, 16 of the Constitution. To hold that the tribunals have no power to handle matters involving constitutional issues would not serve the purpose for which they were constituted. On the other hand, to hold that all such decisions will be subject to jurisdiction of the High Court under Article 226 to 27 of the Constitution before a division bench of the High Court within whose territorial jurisdiction the tribunal concerned falls will serve two purposes. While saving the power of judicial review of legislative action vested in the High Courts under Article 226, 27 of the Constitution, it will ensure that the frivolous claims are filtered out through the process of adjudication in the tribunal. The High Court will also have the benefit of recent decision on merit, which will be of use to it to finally deciding the matters. So that part also can be handled by the tribunal now, that legislative area. Now paragraph 93. Before moving on to other aspects, we may summarize our conclusions on the jurisdictional power of this tribunal. The tribunals are competent to hear matters where the virus of statutory provisions are questioned. However, in discharging this duty, they cannot act as substitute for the High Court and the Supreme Court, which have, under our constitutional setup, been specifically entrusted with such an obligation. Their function in this respect is only supplementary, and all such decisions of the tribunal will be subject to scrutiny before a division bench of the respective high courts. The tribunals will consequently also have the power to test the virus of subordinate legislations and rules. However, this power of the tribunal will be subject to one important exception. The tribunals shall not entertain any question regarding the virus of their parent statute, following the settled principle that a tribunal which is a creature of an act cannot declare the very act to be unconstitutional. In such cases alone, the High Court concerned may be approached directly. All other decisions of this tribunal rendered in cases that they are specifically empowered to adjudicate upon by virtue of their parent statutes will also be subject to scrutiny before a division bench of their respective high courts. We may add that the tribunals will, however, confine to act as the only court of first instance in respect of areas of law for which they have been constituted. By this, we mean that it will not be open for the litigants to directly approach the High Court, even in cases where they question the virus of the statutory legislation, except as mentioned where the legislation which creates the particular tribunal is challenged by overlooking the jurisdiction of the tribunal. Very categorical opinion of the Honorable Supreme Court by a 5 judges bench, Lordship. Sorry, I'm sorry, 7. So we may add that the tribunals will, however, continue to act as the only court of first instance. That is why we said that let them go there. We also lose a forum because the order of or findings of the tribunal can always be tested before a division bench, before going to the Supreme Court if somebody wants to go, in respect of the area of law for which they have been concerned. By this, we mean that it will not be open to the litigants to directly approach the high courts, even in cases where they question the virus of the statutory legislations. Repeating the same in paragraph 99. In view of the reasoning adopted by us, we hold that clause 2 of Article 223A and the clause 3D of the to the extent they exclude jurisdiction of the High Court and the Supreme Court under Article 226 and 32 of the Constitution are unconstitutional. Section 28 of the Act and the exclusion of jurisdiction clauses in all other legislation enacted under the aegis of Article 323A and 323B would to the same extent be unconstitutional. The jurisdiction conferred upon the High Courts under 226, 227, upon the Supreme Court under Article 32 of the Constitution is a part of the inviolable basic structure of our Constitution. While this jurisdiction cannot be outstayed, other courts and tribunals may perform a supplemental role in discharging the powers conferred by Article 226, 227, and 32 of the Constitution. The tribunal created under Article 323A and 323B of the Constitutions are possessed of the competence to test the constitutional validity of statutory provisions and rules. All decisions of these tribunals will, however, be subject to scrutiny before a division bench of the High Court within whose jurisdiction the tribunal concerned falls. Now, this is important. The tribunals will nevertheless continue to act like court of first instance in respect of areas of law for which they have been constituted. It will not therefore be open to litigants to directly approach the High Court, even cases where they question the virus of statutory legislation, except where the legislation which creates the particular tribunal is challenged. By overlooking the jurisdiction of the tribunal concerned, Section 5(6) of the Act is valid and constitutional and is to be interpreted in the manner we have indicated. So this finding and this ratio is directly applicable to our case also. They are challenging an administrative order apart from selection and recruitment process. Prayer number 1, 2, and 3 are relating to the selection process held in September, which was actually not a selection process. Selection process held in the month of December 21st. They have not challenged that. They have not challenged the appointment also of 19th February. They have challenged the shortlisting exercise, which is not a part of the statutory norms. When all the departments send names, the government of Assam in the personnel department decided that we'll select 10 to 15 persons for final selection by the UPSC. Under the norms and under the statutory provisions, there is a specific selection committee. That exercise was done in December. Prior to that, October 27th notification was issued. And this is for the first time non-SCS persons were nominated. This is the first time in 2017. All along, for long 20 years, there was not a single person who was appointed from the non-SCS category. That is why it was necessary to give the equivalence. And the learned single judge held that in the civil service code, the equivalency should be there. No, there are three parallel rules in operation. One relating to the industry department, one relating to the taxation department, and third to the general civil services. How can civil services include this post in their category? For that, one nodal department will have to issue a notification. And that notification was issued under Article 162. And it was not that these two persons who were finally selected got it out of any favor. When they were selected, they continued to hold not only those posts, which was given equivalency, they were much above those posts when they were selected. Superintendent of taxes is one example the other side was giving. He was superintendent of taxes about much before 2010, much before 2008. The selection took place in 2017 and 18. He was holding a much higher post, and recently he retired as the commissioner. I think he retired as commissioner of taxes. So it is not that the government favored somebody. And how can we favor? If we have favored the other 10% or 15% who were sent for nomination, they would have come before this honorable court. And we do not have any blue-eyed person anywhere, at least this government. So this finding was relied by the learned single judge in the Arunachal case now. Two 2015 1 GLT 588.
Yes.
Paragraph 2 onwards, I'd like to read, Lordship, because the similarity of facts here. In paragraph 26 of the judgment, this judgment was distinguished. So I'd like to place Mr. So-and-so learned additional advocate general Arunachal has submitted that as per communication received from the Union Public Service Commission, the selection committee meeting connected with the instant writ petition is scheduled on 12/9/2014. And he also brought to the notice of the court the order dated 28/8/2014. Sri so-and-so submitted that there is an urgency in the matter and the parties have already exchanged their affidavits and thus paid for before this court to take up the matter for finality. In this regard, learned counsel for the petitioner private and the respondents have expressed their consent and agreed the matter be finally heard at the admission stage. Coming to the next page, paragraph 3. The Government of India in the Department of Training, Ministry of Personnel, Public Grievance and Pension, Delhi, by DO letter dated 7/12/2013, requested the chief secretaries of all state governments to provide with the information for determination of number of vacancies in the promotion quota of IAS, both in the state civil services SCS and non-state civil services non-SCS categories. Also informing that for promotion quota of IAS from non-SCS category, this is again the same thing here also, is desirable that every one vacancy expected to be determined, names of 5 officers serving in connection with the affairs of the state and not belonging to the state civil service are sent, and further informed that the same shall be furnished as per pro forma and closed with the certificates latest by 15 January 2014. Pursuant to the same, the state government in the personnel department Arunachal, by communication dated 28/1/2014 informed ours was 28/2/2017, the same exercise. Here 28/1/2014 informed all commissioners and secretaries of the state of Itanagar to forward the names of the officers who are less than 54 years of age and outstanding APR for last 8 years in the grade of grade A under their control with their complete biodata, etc., etc. Next paragraph. In terms of the same, the present petitioner, namely Sri Tajuk Charu, Director of Printing, Arunachal, Naharlagun, by his application dated 7/2/2014, submitted his complete biodata with the APR of last 8 years and other certificates before the Secretary, Itanagar, for consideration for promotion to IAS under the quota of non-SCS category. The said applications of the petitioner was recommended by the concerned Secretary, which was received by the Department of Personnel on 21/2/2014. For sending proposals to the Government of India, a preparation of select list of the year 2014 of State of Arunachal Pradesh for promotion to IAS under non-SCS category, the state government in Department of Personnel, dated 27 February 2014, constituted a screening committee with respondent number 5 as the chairman, respondent number 6 as its members. The State Department on 1/4/2014 stating that the screening committee, also constituted by the government on 27/2/2014, shall held a meeting on 2/4/2014 at 11 a.m. to scrutinize the documents of the applicants for promotion to the IS under non-SCS category for sending proposal to the Government of India for preparation of the select list for the year 14. Accordingly, the screening committee in its meeting held on 2/4/2014 scrutinized the documents of 11 such applicants, including the petition, and submitted its report before the Department of Personnel, Government of Arunachal. When the screening committee's report was placed before the Chief Secretary of the state, it was found that same is not in conformity with the necessary requirements and some discrepancies like non-availability of original documents, vigilant clearance reports with regard to any encroachment on the land of government quarter, etc., were not placed before him. And accordingly, the Chief Secretary of the state on 5/5/2014 observed that the committee may meet again and draw proceedings mentioning the award of marks specifically. The Chief Secretary of the state discussed the issue with the Commissioner Personnel again on 19/5/2014, and as he sought for certain clarification on 5/5/2014, after such discussion, it was decided that it will be more appropriate to reconvene the committee by holding a fresh meeting consisting of same members so that the fresh vigilance clearance in respect of all the candidates may be looked into, and some representations have been received for inclusion may also be taken up for consideration. Observed that the said committee may submit its recommendation within 15 days to the. Accordingly, the state government in its personnel department by letter dated 19/5/2014 constituted the selection committee for the said purpose, consisting of the same sets of officers as that of the screening committee.
Come to this para number 7.
7. The petitioner, being aggrieved by such action of recommending the name of respondent number 4 by the re-scrutinizing committee dated 4/6/2014 in the promotion quota of IS under the non-SCS category on the basis of the order dated 19/5/2014 and circular dated 2/6/2014. This circular also, excluding dropping his name amongst the 5 selected candidates for the said purpose, who was earlier selected on the basis of the recommendation of the selection committee held on 2/4/2014. In terms of the order dated 27/2/2014, as and circular dated 1/4/2014, has filed a writ petition. The main contention of the writ petitioner herein is that the application of the private respondent 4 was recommended by the departmental secretary on 30/5/2014 for lateral induction to IS, much after the expiry of the mandatory period prescribed by the state government, and the illegal action on the part of the state government in considering his said application and to include his name in the recommended list in place of the petitioner. I am keeping. Yes.
The question was that it was not the question that it is the post of the person which was respondent number 4 was holding the post, which was not equivalent to IAS, was sent, but only after the period was expired. This is what the question before the.
I agree, Lord. Minor differences here and there on factual, whether that will.
Difference of a significant difference.
Significant difference, Lordship. Now, what is the main recruitment process? The Supreme Court says that all matters relating to recruitment should be covered by Section 14 and it should be adjudicated by the CAT.
Yes.
That is the court of first instance.
Yes.
Even there is a challenge to the virus of any rules also. The tribunal is empowered.
Yes.
In that situation, whether by bypassing that forum, straightway, a person can straightway come to under Article 226 to the Honorable High Court. That is my main limb of argument, Lordship, here. That whether it is permissible, because the Supreme Court in two paragraphs, 93 and 98 or 97, said that they are barred from coming to the High Court directly.
Yes.
So now here, there may be minor difference or, as Lordship said, major difference. Whether that will dilute the constitutional bench judgment or not. Because the tribunal is empowered to look into both the situations. Now, paragraph 10, the question which arises for consideration before the court now is whether this petition is maintainable in the present form under Article 226 of the Constitution, and the court deem it fit to and proper prior to entering into the merit of the case to determine the issue of maintainability. This is what we prayed. And we place this judgment also.
Directly come to vote.
From paragraph 24, the findings.
Yes.
From the reading of section 14(1) of the Assam Administrative Tribunal Act, it is very clear that the CA
23.
Lordship.
Para 23, start from.
Lordship. It is clear from the communication of the Government of India dated 7/12/2013 that the Government of Arunachal is required to recommend the names of non-state civil service officers for consideration of promotion to IAS quota of the state. So it is the post of IAS Indian Administrative Tribunal under the Union of India, which is All India Service under All India Services Act 1995. Sorry, it should be 1951, as well as under Article 312 of the Constitution of India. From the reading of section 14(1) of the Administrative Tribunal Act 1985, it is very clear that the CAT has the jurisdiction with regard to recruitment and matters concerning recruitment to any All India service or any civil services of the Union or a civil post under Union or to a post connected with the defense or in the defense services, being in either case a post filled up by civilian. From section 3 and section 14(1) of the Administrative Tribunal Act 1985, it is the post to which the candidate or an incumbent is going to be recruited that determines the jurisdiction of the CAT and not the actions of the state agencies while making any selection, recommendation, etc. In the present case, the terms of the aforesaid communication of the Government of India dated 7/12/2013, the state respondents have taken up the process of selection and recommendation of the names of the candidates from the non-SCS category of the state for promotion quota to the recruitment of IAS of the state, which falls under the category of All India Service. Therefore, in considered opinion of the court, the petitioner cannot invoke the extraordinary jurisdiction of this court under Article 226 of the Constitution of India against the selection and recommendation of the state respondents in recommending the names of the non-SCS officers of the state to the central government for consideration of promotion quota to IAS of the state. As such, in present case, it is the CAT which has the jurisdiction being the court of first instance. The writ court in a division bench under Article 226 to 27 has jurisdiction to entertain only the matters that arises from a decision of the administrative tribunal created pursuant to Article 323A, 323B of the Constitution. For the aforesaid reasons, the court upholds the preliminary objections raised by respondent 4 and the writ petition is not maintainable.
Yes.
So my humble submission is that when there is an existing principle in force after the Constitution bench judgment, that has to be abided by all courts of the country. There cannot be any deviation. The law is well settled without any ambiguity. There is no vagueness of both the paragraphs which I have placed before this honorable court. That they should directly go to the tribunal, not before this honorable court. If any litigant has any grievance relating to recruitment and service conditions, service recruitment conditions of the to the All India Services post. So in that line, Lordship, I would like to just refer to the official liquidator's case regarding judicial discipline, which I do not think I have to place it. Lordship knows it very well. Otherwise, there will be total anarchy and there will be no confidence on the lawyers also from the people. And on minor differences, the law cannot be diluted. That paragraph I would like to place. It is where the Uma Devi's case was violated and the Honorable Supreme Court came up very heavily on another two judges bench of the Honorable Supreme Court.
Judgment get a situation.
Yes, sir.
Various paragraphs are very important, Lordship. From 75 onwards, here, by virtue of Article 141 of the Constitution, the judgment of the Constitution bench in case of Karnataka versus Uma Devi is binding on all courts, including this court, till the same is overruled by a larger bench. The ratio of the Constitution bench has been followed by different two judges bench for declining to entertain the claim of regularization of service made by ad hoc, temporary, daily wage, casual workers, or for reversing the orders of the High Court granting relief to such employees. However, in UP versus Puran Singh Pandey, on which reliance has been placed by Sri Gupta, a two-judge bench has attempted to dilute the Constitution bench judgment by suggesting that the said decision cannot be applied to a case where regulation has been sought for in pursuance of Article 14 of the Constitution, and that the same is in conflict with the judgment of 7 judges bench of Maneka Gandhi versus Union of India. The facts of UP versus Puranche was that the respondent number 4, etc. Lordship, I am not going into this paragraph. The principles which has been laid down. Paragraph 70. 77, there is a 78. There have been several instances of different benches of the High Court not following the judgments, orders of coordinate and even larger benches. In some cases, the High Court have gone to the extent of ignoring the law laid down by this court without any tangible reason. Likewise, there have been instances in which smaller benches of this court have either ignored or bypassed the ratio of the judgment of larger benches, including the Constitution benches. These cases are illustrative of non-adherence to the rule of judicial discipline, which is sine qua non for sustaining the system. In Mahadevlal Kanoria versus so-and-so, paragraph 19, if one thing is more necessary in law than any other thing, it is the quality of certainty. This quality would totally disappear if judges of coordinate bench jurisdiction in a high court started overruling another's decision. If one division bench of a high court is unable to distinguish a previous decision of another division bench and holding the view that the earlier decision is wrong, itself gives effect to that view, the result would be utter confusion. The position would be totally bad, where a judge sitting singly in the High Court is of the opinion that the previous decision of another single judge on a question of law is wrong and gives effect to that view instead of referring the matter to a larger bench. In such a case, lawyers would not know how to advise their clients, and all courts subordinate to the High Court would find themselves in an embarrassing position of having to choose between dissenting judgments of their own high courts. Then coming to Paragraph 81. In our system of judicial review, which is a part of our constitutional scheme, we hold it to be the duty of the judges of superior courts and tribunals to make the law more predictable. The question of law directly arising in the case should not be dealt with apologetic approaches. The law must be made more effective as a guide to behavior. It must be determined with reasons which carry convictions within the courts, profession, public. Otherwise, the lawyer would be in a predicament and would not know how to advise their clients. Subordinate courts would find themselves in an embarrassing position to choose between the conflicting opinions. The general public should be in a dilemma to obey or not to obey such law and ultimately falls into disrepute. Paragraph 82. In Vijay Lakshmi Sadhu versus Jagdish, court considered whether the learned single judge of the Madhya Pradesh High Court could ignore the judgment of a coordinate bench on the same issue and held, as the learned single judge was not in agreement with the view expressed in Devilal's case, it would be more proper to maintain judicial discipline to refer the matter to a larger bench rather than to take a different view. We note it with regret and distress that the said course was not followed. It is well settled that if a bench of coordinate jurisdiction disagrees with another bench of coordinate jurisdiction, whether on the basis of different arguments or otherwise, on a question of law, it is appropriate that the matter is referred to a larger bench for resolution on the issue, rather than to leave two conflicting judgments to operate, creating confusion. It is not proper to sacrifice certainty of law. Judicial decorum, no less than legal propriety, forms the basis of judicial procedure, and it must be respected at all costs.
These are the judgments on which the.
One very important line, paragraph 90, Lordship.
Yeah.
Every paragraph is very relevant. Paragraph 90. We are distressed to note that despite several pronouncements on the subject, there is substantial increase in the number of cases involving violation of the basics judicial discipline. The learned single judges and the benches of the High Court refuse to follow and accept the verdict and law laid down by coordinate bench and even larger benches by citing minor differences in the fact as the ground for doing so. This is what I am trying to emphasize. On minor differences, it cannot be diluted, Lordship. Therefore, it has become necessary to reiterate that disrespect to the constitutional ethos and breach of discipline have grave impact on the credibility of judicial institution and encourages chance litigation. It must be remembered that predictability and certainty is an important hallmark of judicial jurisprudence developed in this country in the last 6 decades, and increase in the frequency of conflicting judgments of the superior judiciary will do incalculable harm to the system in as much as the court at the grassroots will not be able to decide as to which of the judgments laid down the correct law and which should be followed. 91 also, Lord. We may add that in our constitutional setup, every citizen is under a duty to abide by the Constitution and respect its ideal and institution. Those who have entrusted with the task of administering the system and operating various constituents of the state and who take oath to act in accordance with the Constitution and uphold the same have to set an example by exhibiting total commitment to the constitutional ideals. These principles is required to be observed with greater rigor by the members of the judicial fraternity who have been bestowed with the power to adjudicate upon important constitutional and legal issues and protect and preserve the rights of the individuals and society as a whole. Discipline is sine qua non for effective and efficient functioning of the judicial system. If the courts commands others to act in accordance with the provisions of the Constitution and rule of law, it is not possible to countenance violation of the constitutional principle by those who are required to lay down the law. In the light of what has been stated, that we deem it proper to clarify that the comments and observations made by the 2 judges bench in Puran Singh Pandey should be read as obiter and same should not be treated as binding. So this is my humble submission, Lordship. The law is very clear that if the other side has any grievance, the right forum, as indicated, as shown by the L. Chandra's case, constitutional bench comprising of 7 judges, they should follow that, not before this honorable court. And in that view of the matter, Lordship, there is some infirmity in the learned single judge's judgment that it is a maintainable case. In my humble submission, it is not maintainable at all. And if they only resort to the challenge to 27 October's notification, definitely they can proceed in this honorable court. This is my humble submission.
Which client is already retired.
We also filed an appeal, my lord, writ appeal 166 of 2018. Adopting the same argument, my lord, of my learned friend. Just I'd like to draw your lordship attention again to 14 of the Administrative Tribunal Act. 14 of the Act. Lordship got 14, my lord. Judicial power and authority of the Central Administrative Tribunal. Save as otherwise expressly provided in this act, the Central Administrative Tribunals shall exercise on and from the appointed all the judicial power and authority accessible immediately before that day by all court except the Supreme Court in relation to A, recruitment and matters concerning recruitment to any All India service or to any civil service of union or a civil post under the union or to a post connected with defense or in the defense services, being in either case a post filled by a civilian. So if your lordship kindly see A, recruitment and matters concerning recruitment. Now if your lordship kindly see definition 3Q, kindly turn to my lord 3Q. Lordship got it, my lord. 3Q. Service matters in relation to a person means all matters relating to the condition of his service in connection with the affairs of the union or any state or any local or other authority within the territory of India or under the control of the government of India or as the case may be, any corporation owned or controlled by the government or in respect. So, my lord, it has been defined under 2Q that in relation to any matters, my lord, condition of saying connection to affairs of union or in state. Now the process which my learned friend I don't want to repeat, mine started from the sending the names which they have sought for. That's please send the names. So in my petition will be almost same. There was a minutes of meeting which the person's name was sent. About 15% name was sent. Among them it was selected. Now this starts why I'm pointing 3Q is in connection that in respect of recruitment to the service is governed by All India Regulation Service Regulation. Now this All India Service Regulation, if your lordship kindly see my petition, writ appeal, which I have annexed, it is all governed. And it is why I'm showing it is by virtue of control of the central administration. Now this is, your lordship will kindly see, there are 1 rule and 2 regulation. How the names are to be sent, it is here under this. Kindly see first 97, my lord. See please 97, my lord.
You're referring to which writ appeal?
A writ appeal 166, my lord, of 2018.
Yes.
If your lordship kindly see 97, and for before that, if you keep your lordship one hand and see the minutes of meeting at page 37, which at page 37 first,
Yes.
the minutes of meeting of the selection committee for preparation of non-SCS officer to be recommended for nomination to IS for select list 2006 held on so and so in the office chamber of so and so. So these are the members present. The committee was informed that the DOPT Government of India determined 2 vacancies in Regulation 3 of so and so under Regulation 3 of IS appointment of selection regulation 1997 for selection list of 2016. Now your lordship will kindly see 97, page 97.
Yes.
So if your lordship kindly see, this committee is 2A. 2A is a committee, means a committee as constituted in Regulation 3 of the Indian Administrative Appointment Promotion Regulation 1955. And this committee, if you see at page 86, is a constitutional committee. See, please see page 86. These are the committee is defined, means the committee set up in accordance with Regulation 3 at page 86. Lordship got it, my lord?
Yes.
This is D. Committee means committee set up in accordance with Regulation 3. Now, please turn to page again 97. Determination 3, my lord. 3. Determination of vacancy to be filled. The central government sent in consultation with the state government concerned, determine the number of vacancy for which recruitment may be made under this regulation each year. Number of vacancies shall not exceed the number of substantive vacancy as on the first day of January year in which the meeting of the committee to make the selection is held. So why I was showing, my lord, first 14, the recruitment to matters concerning service. Now what is defined on the 3Q is what is service matter, that it contains not a union or the state. Now, how a selection recruitment to the service is being held under this regulation. So it is appointment are being made in respect of these 2 regulation and 1 rules, which I have annexed here. I am not on the merit of the case. I am on the maintainability, which is governed under this and which supports L. Chandra. That's what I was showing before your lordship. Now, if your lordship kindly see at page 97 again, 97 C4, my lord. Kindly C4. State government to send proposal for consideration of the committee. The state government shall consider the case of person not belonging to state civil service, but serving in connection with the affairs of the state, who is an outstanding merit, holds a gazetted post, has completed not less than 8 years of continuous service under the state government on the first day of January of the year, in which case is being considered in any post which has been declared equivalent to post of Deputy Collector of State Civil Service and propose the person for consideration of committee. Number of person proposed for consideration committee shall not exceed 5 times the number of again proposed to fill up. So if your lordship kindly see what the state government has done, issued a notification, is equivalent to that post. 8 years we are serving, continuous service, which your lordship will kindly see at page 42. Now, preparation of a list 98, a suitable officer by the committee. Now, if your lordship kindly turn to page 86. Sorry, 87. Now kindly turn to page 78, my lord. All this point can be agitated before the central administrator, what I am showing before this court. And these are the rules and the regulation which governs. My lord, C78, the Indian Administrative Service Recruitment Rule 1954. Commission means the union public. Service means, lordship got it?
Yeah.
That is A, E, and D. State service means for the purpose of filling the vacancy in administrative service cadre so and so. Kindly turn to page 79. 79, method of recruitment of service. Recruitment of state after the commencement of rules shall be made by following, namely B, by promotion, member of state civil service, where it is regulated, my lord, at page 1955, that is your page 86. Now kindly see C, by selection in special case from among person who holds in the substantive capacity gazetted post in connection affairs of a state and who are not members of state civil service. Now, if you see, now at page 82,
Yes.
please see 82. 8.
Yes,
See rule 8, my lord.
yes.
Recruitment, promotion or selection for appointment of state and joint cadre. 8.2 is important. 8.2. The central government may in special circumstances recommendation of the state government concerned and in consultation with the commission and in accordance with such regulation as the central government may, after consultation with the state government and the commission, from time to time may recruit to the service any person of an outstanding ability and merit service in connection with the affairs of the state who is not a member of the state civil service of that state, who hold a gazetted post in a substantive capacity.
So your submission is that this is all related to this recruitment or matters concerning recruitment.
Yes. So all these are governed. So if you are aggrieved
And in
by
that case,
any
we
of
are
then only cat of the first instance, which my learned friend has argued. I don't want to repeat El Chandra as your learned friend has shown. Only this is what my argument is, my lord. Now, in addition to that, one of the judgment of the Supreme Court, my lord, I'll just show it, which was followed. So before this.
Yes.
Before recession, I pointed out before your lordship that these are 1 rules and 2 regulation. So far as the recruitment, so far as the service matters are concerned, is all governed under this. So if you are really aggrieved by this, so your option was to go to the court of first instance. Now, one judgment of the apex court, one more, which they relied, is 2010 4 SCC, that 554. Lordship will kindly look into that judgment. I will not repeat the judgment of El Chandra because my learned friend already have shown those paragraphs, which I will also rely on the same paragraph. Kindly see para 13, my lord. 13. Para 13. Small 3 paragraphs. 2010 4 SCC 554. They relied again on L. Chandra Kumar case, my lord. Para 13, in view of such repeated and authoritative pronouncement by the constituent bench of this court, the approach made to the High Court for the first time by this in respect of their service dispute over which CATA jurisdiction is not legally sustainable. Division bench of the High Court with great respect fell into an error by allowing the appellant to treat the High Court as a court of first instance in respect of the service disputes for adjudication of which CAT has been constituted. The grievances of the appellant in this appeal are they were not made party in the proceeding. Impleadment application filed by before the High Court, if it was not averred, they were not aware of the pendency of the proceeding before that. That's what they came before the court. Rather, from the averment made in the impleadment petition, it appears that they were aware of the pendency of the proceeding tribunal. It was therefore open for them to approach the tribunal with their grievances. Not having done so, they cannot, in view of the clear law laid down by constitution bench of this court, approach the High Court and treat it as a court of first instance in respect of the grievances by overlooking the jurisdiction of a tribunal. CAT also has the jurisdiction of review so and so it cannot be said the appellant were without any remedy. As the appellant cannot approach the High Court by treating as a court of first instance, their special leave petition is also incomplete and not maintainable. So ultimately, my N. Chandra Kumar is relied on, and that's a constitution bench judgment. If they said we were not aware of the proceeding, they said that the first court is there. You go for a tribunal. Why you have come before this act? But High Court made an error. That's what the apex court said. Now, one judgment. Last, I will show a judgment of the Bombay High Court Division Bench of 2022. 2022 SEC Online Bombay 476. Yes. My lord will see para 3. First, second, third, fourth, fifth, sixth, seventh, eighth line. Eighth line. Or para 3, 8th line. 1, 2, 3, 4, 5, 6, 7, 8th line. Read petitions. Lordship had got it?
Yes.
8th line. Read petition have been listed before us on 2nd of March. We have expressed in no uncertain terms that the petition ought to be relegated to the mat for relief. Now, Lordship kindly turns to para 8. His discussion has been made. Para 8. Now see para 14, my lord. I'm not troubled. Para 14. Now, why your lordship just recollect? My lord, 3Q has been shown to your lordship. 3Q of the definition. See para 14. It is therefore preludes that the 42nd Amendment 1976 having divested the High Court of its power of judicial review in relation to service matter of central state government employees and other notified employees, but the Supreme Court having held jurisdiction conferred upon the High Court under Article 226, 227, and upon the Supreme Court under Article 32 of the Constitution be a part of the inviolable basic structure of our Constitution, leading to striking down of subclause D of clause 2 of Article 323A and Section 28 of the Act, to the extent of excluding the jurisdiction of the High Court. A vacuum was created with the Supreme Court by the process of judicial legislation intended to fill up. High courts were conferred the jurisdiction to exercise power of judicial review and superintendent under Article 226, 227 by reason of such authoritative pronouncement in L. Chandra Kumar case. Now, this is important. 15. To the less discerning and uninitiated, High Court can still be directly approached by the central state government employees and other notified employees regard being had to the decision in L. Chandra Kumar, if at all the proceeding initiated before the court touching service matter includes a challenge being laid to any of the provision of the Act, which the tribunal being a creature of the Act would be unable to examine. That apart, notwithstanding has been said in L. Chandra Kumar, employee could also approach the High Court directly in two other situations. First, in a situation like one in T. K. Rangarajan Supra, my lord, that's more than lakh people was involved. Lakh people were more than 1 lakh people involved. And secondly, if the administrative tribunal are non-functional for any reason whatsoever, here at that relevant time, my lord, maybe some members were not sitting. Moreover, this is not the case in this state where the benches of the mat at Mumbai, Nagpur are functional, with retired judge of the court at the helm of such benches. 16. Now, this is the last paragraph. Having regard to such scheme of things which could be pursued by an aggrieved employee, we are also the firm view that the law laid down in Whirlpool, carving out exception on the fulfillment whereof a writ petition could be directly entertained, notwithstanding the litigant has not availed the alternate remedy made available by a statute, cannot be applied to proceeding seeking to invoke the jurisdiction of the High Court for relief when the subject matter of the action is covered by service matter as defined in Section 3Q of the Act. So here, my lord, definition of 3Q of the Act, service matter including sending of the name and selecting it. So it is all by virtue of the purview where it be entrusted to the CAT. So the best was to go to the court of first instance, that's the CAT. That's my respectful submission before this court. And that particular point.
How are you prejudiced, leaving aside everything, supposing the matter is decided by the High Court instead of the CAT? How are your clients prejudiced?
Now, my lord, we have retired now. We have retired. We have retired. Now, my learned friend says that we should be put back to what we originally were.
So that is on merit. That's another
That's
matter.
what I am. We are because now, suppose for a moment.
The query is, if this matter, for whatever reason, subject to all arguments made, whatever the view of the court. For example, if this writ petition is decided by the learned single judge, how are you prejudiced?
Oh, we prejudiced because it is not maintainable. First of all, it is not maintainable. First, our ground coming.
So you are arguing that there is an exclusion of jurisdiction.
Yes, that's what.
That we cannot accept.
That's what we are arguing.
Clearly makes it that there is no exclusion of jurisdiction of High Court.
That's what my point is this, my lord.
93
Maintainability
is very
point.
clear. Supreme Court says there is no exclusion of jurisdiction.
So that's why my maintainability point was raised before the learned single judge, my lord. Lucas, of course.
Mr. Das, the simple query we are trying to figure out is, how are you prejudiced if the matter is decided by the single judge and not the CAT? What is the prejudice that
No,
will be
that's
caused?
the CAT, what I was pointing out before the court, whether the High Court or the will be for court of first instance. Otherwise, always it will be, my lord, they will come before not this litigation, my lord. Any other litigation will, because this will be a precedent, my lord.
See, the point is not that. Your arguments are correct if you are arguing the matter before the single judge on the point of maintainability, then it is one way of looking at the thing. We are today looking at the order of the single judge to ascertain if the order is erroneous.
I am telling your lordship. Now I'll give an answer to your lordship.
That order will be
No, I will
erroneous if
give an
there is
answer.
exclusion of-
The order is erroneous on the ground that this was at first an ex parte order. When it was moved into an ex parte order, we came before the court and our whole contention before the learned single judge was that it is not maintainable. So now order has been passed by the
नहीं, they how they will be different. वो भी DV में आएगा, इसका judgment भी DV में.
now,
You are
now,
not
my lord.
deprived. Mr. Saika has argued that you will be deprived of a forum. That's not correct.
No, what my argument will be, my lord, my argument will be, when this matter was, your lordship, I'll putting a query to your lordship answer. Number one is that when initially it was heard, it was an ex parte. Thereafter, we received notice. We appeared before the learned single, we have seen the order. We filed an application that this particular writ petition is not maintainable. Whatever arguments I advanced before your lordship, putting all these rules and regulation with 14 and 3Q, that was the argument which was advanced. It is not maintainable. Now the learned single just giving a finding to the extent that it is maintainable. On merit, it has not been decided. So against this maintainability we have before this honorable court, the learned single judge should not have invoked the judicial under Article 226. That's our case. That's the answer, my lord, with great respect, my lord.
But you are not facing any prejudice.
My lord, of course, now I have retired. It's not that, now suppose today the interim order is vacated. There is an order which has been passed. The order of the learned single judge has been stayed. Our whole case is that there was an appointment which was made that was not brought notice to the court. Now there was an interim order which was passed.
And what do you have to say, Mr. Saika's submission, 2710 order, he says that can be challenged, then the writ petition will be maintainable.
2710, that's particular, that equivalence, my lord. Yes. But with that, my lord, I just respectfully just differ on this ground because it is regulated by a regulation. Your lordship, I read that. So all that can be also argued and agitated before the first court of instance. That is the reason why I have shown. My lord, your lordship will recollect. There are two regulations which I have shown and one of the rules which I have shown. How this has to be said. These are all India service, my lord. So this is open. That also can be put to challenge. Is now, my lord, is dissected, digradated into two parts. One part they are saying it is wrongly it has been, how it can be equivalence part. So this can be put to challenge before the CAT. That's the reason why I have shown, my lord. This part also could be challenged. Now there is my respectful submission, there is a bifurcation. They said, no, this is what the equivalence has been by the state. This equivalence is by notification by the state.
Yes, Assam Civil Service rules, Assam Civil Service rules 1998. Para 19 is there. Other, that's a association.
Now raise this objection regarding the maintainability of the locus of the.
Yes, also,
association.
yes, 120, that's particular from starting from 113, page 113. It starts and this point we have reached at page 119 it starts. We are respond number 8 in the writ court, my lord. 119.
119.
That's your lordship is holding 166,
Yes.
page 113. 113. That's an application which we have filed for modification variation of the order.
No, that is.
And my lord will kindly see the judgment at page 8.1. That's 8.1. That specifically our prayer was. 8.1. My lord will kindly trouble your lordship 242. We have all these are objections. See page 242, my lord. To all the judgment. 8.1. 8.1. The judgment of the learned single judge.
Judgment.
Yes.
8.1.
This is on the basis of our application on 226.3.
Mr. Representing respondent adopting the argument as well as so contains the petition cannot be aggrieved party in selection with the IAS cadre. Yes.
That's what we said. This is what your lordship has put a query, I remember, to my learned friend. So I didn't say, I just noted down. That's a point, my lord.
That's a very crucial point.
That's a point why we raise that point, my lord. Somebody agree, ABC, agree that person is okay. Some association coming and raising a grievance. And this specifically, that's why, well, I'm sorry to say, my lord, that's the why I've taken some time. That's the reason why it's a rules, regulation I have shown, my lord.
But you do agree that this equivalence would have to be incorporated in schedule 1.
That should have been, my lord.
That was not done.
But it was not done. But let us put it this way. What makes a difference? Suppose, what makes a difference? I'm putting myself that it should have been done. But my lord, all this, the appellant before lordship, this equivalence long back, 1995, that equivalence has been done. This is only a procedural lapse. They should have done it. I'm saying they should have done it. Now, if they have not done it, this is a part to be challenged before the CAT. If they have not done, this is one.
The names were recommended earlier. Then the equivalence.
So my lord. This is not a service matter. So my lord, if this is a service matter, so can you now bifurcate both and say no? We'll first see how it has been sent. Let the High Court examine it. With great respect, I'll say all these are covered by.
All right, we have noted. We'll give our reasons.
I appeal item number 10. I adopt the submission made by the learned. Okay, there is the opinion.
What is item number 10?
Well, that is filed by the respondent number 9. One of the.
One of,
Eight and nine.
Two of the officers from
Both
all
have
the
retired.
CS,
Both
both
are
are retired.
retired in
Retired.
December.
Only what I am worried, let us put it this way, my lord, suppose today, for a moment, your lordship said it is maintainable. We send it before learned single judge and set aside the order of the division bench. Then the order of the learned single judge will prevail. What's the interim order that was passed by this honorable court? Or by the time I retired?
Interim order, how that will affect you now?
No, my lord, what I am saying that interim order, I am putting, my lord, suppose your lordship decides that no, it is, we'll send it before the learned single judge. Let us put.
First of all, we have to decide whether it is maintainable or not.
No, that's true, my lord. Now, suppose it is maintainable, then we have been protected by an order. The order of the learned single judge has been stayed. Order of the learned single judge has been stayed. By the time, why? Why? Because by the time the notification appointment has been made, that was not disclosed before the learned single judge. So we came up we have an appeal disclosing that already appointments were made.
No, this was already, in fact, you made it clear before the learned single judge.
No, I made it, but your lordship will kindly see.
This fact was brought into the notice of the learned single judge.
Yes.
On a subsequent date, and learned single judge has continued that.
But that we brought it because that was not a part of pleading before the appointments. They moved the writ petition after the appointments were made, my lord. 27th of February and 19th of February, my appointments were made.
And 28th February was the first order.
That's right, my lord.
And thereafter, another order is there of the learned single judge, whereby the stay order was continued while noting this, that
Right.
appointments were already.
26
recommendation
for
and
80. Right,
appointments were
right,
already-
26 for 80. No, that's my humble submission before your lordship, my lord.
Wait, Vijay. Yes.
implement in
My lord, with the grievance with which we went to the learned single judge, with the same grievance, we could have gone to see it. There's no dispute. Question is whether even in spite of L. Chandra Kumar, even in spite of section 14 of the Administrative Tribunals Act, whether we could have approached this honorable court. This is the issue, my lord. Now, as Honorable Justice Shyam has pointed out a very, very significant point, my lord, that it is one thing to say that before the learned single judge, the point is decided either way, against which an appeal is preferred, and in appeal, what we wish to be taken. Therefore, it being an appeal on principle, now would your lordships also endorse the view, as is sought to be suggested by the other side, that here is a case your lordship should give a declaration that there is exclusion of jurisdiction of the court. That is something simply not possible, my lord. Article 226 is the basic inviolable structure of the Constitution. In fact, my lord, if your lordship should recollect, in Sampath Kumar's case, the Administrative Tribunal Act as it stood, whereby, my lord, jurisdiction of the High Court was taken away, was upheld. This reference had to take place only because of that. Their Honorable Supreme Court said that no, 226 is a constituent provision. You cannot tinker with a constituent provision by the Parliament in exercise of its ordinary legislative power. So that the approach to the High Court would be there. However, my lord, having regard to the number of service-related matters which was, being proceeded in the High Court, this Honorable Supreme Court was of the view that as a court of first instance, why not an approach should be made to the tribunals? My lord, when we say tribunal, my lord, it doesn't mean CAT alone. It means State Administrative Tribunal also. The problem with the other side is, my lord, they have forgotten to see that there is another tribunal called State Administrative Tribunal. When you read section 3Q or section 14, you can't, my lord, get lost of sight of the State Administrative Tribunal. But the most importantly, in the state of Assam, There is no administrative tribunal in terms of section 4. Therefore, against the grievance of my lord, wrong committed by the state in the issuing the equivalence notifications, we could not have gone to any other forum. Because state administrative tribunal in terms of section 4 is not there. Therefore, I'm bound to come to High Court, because if I cannot approach the High Court, I can definitely approach the Honorable High Court. Now, my lord, another most important point is, if your lordship kindly reads para 99 of the L. Chandra Kumar, their Honorable Supreme Court has used a very 2-1 expression, my lord. Areas of law. Please have a look at the judgment for a moment, my lord. I will not trouble your lordship. These are already read. I'll just, my lord, indicate what is my brief argument. Please come to para 99 once, my lord. Yes. In view of the reasoning adopted by us, we hold that clause 2D of Article 323A and clause 3D of Article 323B to the extent they exclude jurisdiction of the High Court and Supreme Court under 226 to 2732 are unconstitutional. So the constitutional amendments were interfered in. Section 28 of the Act and exclusion of jurisdiction clause in all legislation enacted under the ages of 323A and 323B would to the same extent be unconstitutional. Jurisdiction conferred upon the High Courts under Article 226 to 27 and upon Supreme Court under 32 is a part of the inviolable basic structure of our Constitution. While this jurisdiction cannot be ousted, other courts and tribunal may perform a supplemental role in discharging the powers conferred by Article 226 to 27 and Article 32. Please mind the word, my lord, may, it's not shall. The tribunals created under Article 323A and 323B of the Constitution are possessed of the competence to test the constitutional validity of the statutory provisions and rules. All decisions of this tribunal will, however, be subject to scrutiny before a division bench of the High Court, within whose jurisdiction the tribunal concerned falls. Now, this line is important. The tribunal will nevertheless continue to act like courts of first instance in respect of areas of law for which they have been constituted. These areas of law has to be given a meaning. Now, areas of law is, my lord, if it is section 14, then it is Central Administrative Tribunal. If the area of law is covered by section 15, then it is the State Administrative Tribunal.
Mr. Chaudhary, we have understood your arguments.
Yes.
Please enlighten us on one point.
Yes.
Your association has a number of members.
Yes.
All of them are not going to be in the zone for, you see, for being selected as IAS. As an institution, as an association, all the members do not therefore stand in equal footing.
Correct.
How can you, by an association, SL these orders?
Yes, I'm coming to that. My lord will kindly come to this writ appeal 165, page number. Page 49. Yes, 53 maybe. Yes. My lord will kindly come to, yes.
So therefore,
Yes,
what we wanted to
in
make,
other words, Lordship wants to know how are we, what locus the association.
we have serious reservation on
Yes,
that
yes,
point.
I'm satisfied.
Even if the
Yes, yes. Please come, my lord. In that Orissa case, when Supreme Court said there cannot be PIL in case of service matter, that was in a slightly different context. Because, my lord, normally in a service-related matter, who can be before the court, whose condition of service has been violated. So therefore, to file a PIL, that too by a person other than the person aggrieved. So it is inconceivable. It's not permitted. It's not done. But when the association represents the collective cause of the members of the association, whose interests are, my lord, are being interfered with, then certainly a writ petition can be maintained, my lord. And I'm answering it, my lord. Because under the relevant rules, if the vacancy is 10 in a particular year, in this particular fashion, if, my lord, lordship will kindly see, this recruitment under this regulation is not a matter of course. The state must plead special circumstance. My lord, for appreciating my argument, I'll have to take your lordship to some of the rules and facts. Now, learned Advocate General had made a statement that this is the first time the state has done this. It's wrong, my lord. State has done it several occasions. For example, well, I know my own brother-in-law, he was a technocrat. He was nominated to IS. I know Hemanga Sharma was there. So many others are there, my lord. Recent past, my lord, I appeared for 2 petitioners. They're also from one from tax department, other from labor department. They've also been nominated. So it's not the first time it is being done. But my lord, there is a requirement of the state, on the part of the state, to explain this special circumstance. Number one, special circumstance, and two, why this person is outstanding. Because, my lord, you are giving them a promotion which is absolutely out of turn.
That is on merit.
Yes, that is on merit. No, my lord, to appreciate this argument, this aspect is important. Please come to page 53 of the writ appeal.
Writ appeal number?
165, my lord. There are 3 ways, my lord. I don't know them.
Page number?
Page 53, my lord. 8. Recruitment by promotion or selection for appointment to the state and joint cadre. It's part of the, my lord. The rule starts at page number 49. If an lordship would kindly come to page 50 for a moment.
It's here somewhere.
Method of recruitment to this service, that is Indian Administrative Service, Rule 4. By competitive examination, that is UPSC. B, by promotion of a member of a state civil service, that promotion. And 3, C, by selection in special cases from among persons who hold in a substantive capacity gazetted post in connection with the affairs of the state and who are not members of the state civil service. So these are the 3 ways by which, my lords, a person can become a member of the All India Service. So we are concerned with HC. Then, my lord, will kindly come to page number 53.
Yes.
The central government may, on recommendation of the state government concerned, and in consultation with the commission, and in accordance with such regulation as central government may, after consultation with the state government and commission from time to time, make recruit to this service person by promotion from amongst substantive members of the state civil service. Then kindly come to 2. We were not concerned. Please come to, 2 is required, yes. Central government may in special circumstance and on recommendation of the state government concerned and in consultation with the commission and in accordance with such regulations as central government may after consultation with the state government and commission from time to time, make a recruitment to this, recruit to the state any person of outstanding ability and merit serving in connection with the affairs of the state who is not a member of the state civil service of that state, but who holds a gazetted post in a substantive capacity. Now, please come to 9. Number of persons to be recruited under Rule 8. Then, my lord, will kindly skip over to the next page, 9.1 and 9 proviso. The number of persons recruited under Rule 8 in any state or group of states shall not at any time exceed 33 and 1/3% of the number of senior posts, and the state government, central deputation reserve, state deputation reserve, and training reserve in relation to the state or to the group of states in schedule to the Indian Administrative Service fixation of cadastering regulation 55. So this 33 and 1/3 is regarding promotion from ACS to IS. Now we are concerned with this proviso. Provided that as a promoted for 0.6. Rule is not 15% now. Oh, this is the rule 8. It is a rule. Determine 5. 1. Taragate city governor page 71. These ones there are 160 11. This claim is to be resulted from many factors and putting personal bracket out. We don't know that investor is cited only army. So therefore, we are taking a matter. Here, this particular supporting that we have been association every month is to meet the bond I was trying to draw your lordship's attention to page 54. Why I'm agreeing?
What is that citation of the Odisha judgment? Do you have the citation?
Odisha, my lord.
That
The PIL is
judgment
not
PIL.
maintainable in service matters.
in
Oh,
service matter-
that's, oh, yes, yes. Ki Mohanty. Some Mohanty. I'm getting it, my lord. সার্ভিস মেথড যে পিআই না থাকে দুর্যোধন সাহু versus State of Odisha.
Exact citation.
Citation to just now give it. Duryodhan Sahu. Now, I was trying to draw your lordship's kind attention to page 54, my lord. Why I am aggrieved.
Yes.
Rule 9(1) I have already read. It says, my lord, 33.13% of the post shall be reserved for members of the state civil service. Then the proviso carves out a quota for this route, my lord, non-state civil service. Provided that number of persons recruited under sub-rule 2 of Rule 8, which I have read all just few minutes back, which pertains to this quota, shall not anytime exceed 15% of the number of persons recruited under Rule 8. Now, my lord, year to year, when this vacancy arises, now if your lordship kindly comes to page 71, this was the letter by which, my lord, the 2 vacancies were earmarked. Kindly see. For the year 1116, my lord, this is the letter. This is written by the Undersecretary Government of India Personnel Department to the Chief Secretary of the State. I am directed to refer to the Government of Assam's letter dated so-and-so on the subject cited above and to say that in terms of provisions contained in Rule 4.2b of the IS Recruitment Rule 1954, read with Regulation 5.1 of the IS Appointment by Promotion Regulation 55, it has been decided that during the year 2016, recruitment by promotion to the state segment of the joint Assam-Meghalaya cadre of IS from members of the state civil service.
Where you are reading?
Page 71, my lord.
71.
70, I'm sorry.
Yes. Yes.
I am directed to refer to the Government of Assam's letter dated 30th of January 2017 on the subject cited above and to say that in terms of provisions contained in Rule 4.2b of the IS Recruitment Rule 54, read with Regulation 5.1 of the IS Appointment by Promotion Regulation 55, it has been decided that during the year 2016, recruitment by promotion to Assam segment of joint Assam-Meghalaya cadre of IS from among members of the state civil service for select list of 2016 vacancies arise between so-and-so may be made up to 5 posts in all. So, my lord, out of which, kindly see, it has further been decided that in terms of the provisions contained in Regulation 3 of IS Appointment by Selection Regulation 97, read with relevant provisions and the recruitment rules, and the number of posts up to which recruitment may be made by selection to the Assam segment of so-and-so during the year 15 for the select list of so-and-so, is 2 posts in all. It couldn't have been 2. 15% of 5 is less than 2, my lord. That's why the association was before the court, the Honorable Single Judge. The association is espousing no other cause. The, my lord, rights and, rights of the members of the association. So it is one thing to say, my lord, that a PIL pertaining to service matter cannot be maintained. And it is quite another thing to say that a service association can maintain a writ petition when they, sought to project the, my lord, grievances of the members of the association. Here, my lord, we do not know who would be in the zone of consideration. How do we know, my lord? And secondly, my lord, what is the special circumstance for which state had to undertake this exercise?
That has to be.
No, I'm just pointing. No, that's an important point, my lord. And my lord, learned single judge has dealt with this issue in paragraph 11. (1998) 7 SCC 273.
Relevant for us. আমার হাইকোর্টেরও ডিভিশন বেঞ্চের জাজমেন্ট আছে Division, service matter, that person agreed must come. Is the DB judgment of this court also that person agreed must come in service matter, no PIL. Rules of locus cannot be relaxed in PIL. Are you aware?
Not, to be honest, I'm not aware. Maybe it is there, it is there.
No, we just wanted to see what
Yes,
is. This
yes.
is another matter. This is where a PIL was filed by
Huh.
another body.
Exactly,
This is
exactly.
not a PIL.
This is the judgment, my lord.
That's right.
Normally, we refer to this judgment only.
Correct. This is not a PIL. The
This is
question
not a PI.
whether the rules of locus is correctly applied in this case or not, because who amongst the members of the association would have any right, if at all, to be considered for nomination? That is not clear. So
my lord,
all of them are not in equal.
No, my lord, it is something like this. The association is ACS Officers Association.
Correct.
They have a quota of 33 and 1/3 in every year. Now, the moment by this way the nomination is made, then their quota is decreased. That is how the association is before the court. The association is the ACS Officers Association. It is not that non-civil service office service. This is not that. Am I clear to Lordship, my lord? The Assam Civil Service Officers Association is before the court because, for example, in this case, by giving 2 to these non-state civil service officers, the quota from 33.1/3 quota has been taken up. And Lani Singh has just dealt with that, my lord, at para 11. At page 166. The number of persons to be appointed to IS from both categories under Rule 8.1 and 8.2 must not exceed 33.1/3 of the total cadre strength of all India service in that state or group of states. Those to be appointed to IS from category of non-state civil service officers cannot exceed 50%, 15% of the total quota for both the groups made available under Rule 8 of the recruitment rules. Only 7 vacancies are available for promotion under Rule 8 as per 33.1/3 quota for both SCS and non-SCS category. And from this 15% of it is to be filled up because of cap of 15% under proviso to Rule 1 from persons belonging to non-scheduled SCS category. This provision makes it clear that appointment of undeserving person from non-SCS category will certainly impact the aspiration of the members of the Petitioners Association. Seen from this perspective, state civil service officers, in my perception, can certainly have legitimate grievance, and thus the challenge, the recruitment of the non-SCS category is found to be maintainable on this basis. The locus standi objection raised by respondent is answered against that. And moreover, my lord, vigilance case was pending against this person. Yes, vigilance case was also pending against this gentleman called Rakesh Agarwal.
Now,
Yes.
how pending now?
No,
is
no, no.
prepared.
Now, my lord, to articulate my arguments, my lord, the matter is very simple, my lord. We could have approached CAT. There is no difficulty in saying, there is no gainsaying. Definitely, we could have gone to CAT. Question is whether we could have approached this honorable court or not in the facts of the case. Now, my lord, what was challenged before the learned single judge? The nomination, the approval given by the state to these persons, that too by putting the cart before the horse. First, then finalize the, my lord, persons would be considered. It was followed by that equivalence notification. So these two notification and this equivalence notification was put to challenge. Now, my lord, this equivalence notification per se it is not a matter which it can't be said that it is not relatable to my condition of service of the members of the association. Because it is from amongst the members of the association, my lord, who would be selected. Now, if we are seeing with naked eyes, my lord, people who are not eligible are being selected, thereby eating upon our quota, why can't we maintain a writ petition? End of the day, my lord, we are trying to enforce our fundamental right. When it comes to, my lord, enforcing fundamental right, my lord, our constitution is citizen-centric. It is not state-centric, my lord. That's why, my lord, your lordships, whenever we come up with a grievance, lordship recognizes our grievance and tries to redress it. Now, what is our grievance? Our grievance is some ineligible persons are being sought to be nominated to IS, that too by in a manner by eating up our quota. If it is a constitution is citizen-centric, why your lordships will not take note of this grievance? These are all technical things, my lord. Your lordships has posed a question to my learned friend, how you are prejudiced? Of course, how they are prejudiced, my lord. Whether it is against order of learned single judge appeal lies to the division bench of this honorable court, against the order of the CAT also appeal lies to the division bench of this honorable court. So where is the difficulty? Therefore, my lord, the expression areas of law which has been used in L. Chandra Kumar's case is very significant in this case. The area of law with which we had a grievance partly pertains to, my lord's, jurisdiction under the state administrative tribunal, and partly insofar as nomination part is concerned. Of course, since it is a matter relating to recruitment, it certainly pertains to CAT. So therefore, we could have approached CAT, but there is no gainsaying that we cannot approach this on of this. It's not a case where it can be pleaded by the other side that here is a case of exclusion of jurisdiction of.
It's not a case of ouster of
jurisdiction. And even if we go by, my lord, the plain and simple logic of, my lord, section 21 of CPC also, ouster of jurisdiction of civil code is not to be readily inferred.
Section 9.
Section 9 read with 21, not to be readily inferred. So therefore, my lord, the area of law is section 15. Therefore, I'll draw your lordship's kind attention to section 15. The equivalence, the issue, it's an area of law covered by section 15. Please come to section 15, my lord.
Section 15 of
Administrative Tribunal Act. Section 14 speaks of a situation when a aggrieved person will go to CAT. And section 15 speaks of a situation when the aggrieved person will go to state administrative tribunal, which in our state there is none. Kindly see the opening line. Save as otherwise expressly provided in this act, the administrative tribunal for a state shall exercise on and from the appointed day all jurisdiction, powers and authority exercisable immediately before that day by all court except Supreme Court in relation to, please come to B, all service matter concerning a person, not being a person referred to in clause C of this subsection, or a member, person or civilian referred to in clause B of subsection 1 of section 14, appointed to any civil service of the state or to any civil post under the state, and pertaining to the service of such person in connection with the affairs of the state or any local authority or other authority under control of the state government or any corporation or society owned and controlled by the state government. All service matter pertaining to service in connection with affairs of the state concerning a person appointed to any service or post referred to in clause B being a person whose service have been placed by and such local or other authority or corporation or other body as is controlled or owned by the state government at the disposal of the state government or such appointment. Please come to subsection 3. Save as otherwise expressly provided in this case, administrative tribunal for a state shall also exercise on and from the date with effect from which the provisions of this subsection apply to any local or other authority or corporation, all jurisdiction, power, authority exercisable immediately before that date by all courts except Supreme Court in relation to so and so, so and so, so and so. So, my lord, this equivalence exercise, in my humble submission, subject to what your lordships may say, is an issue which fall within the exclusive jurisdiction of the state administrative tribunal, which the state should have, Section 4, my lord, if your lordship would kindly have section 4. Subsection 2, which still that it is not there, my lord. Central government may, on request, receipt of a request in this behalf from any state government, established by notification an administrative tribunal for the state to be known as so-and-so, to exercise jurisdiction, power and authority conferred on the administrative tribunal for the state by or under the act. If such an administrative tribunal would have been there, then state would have been perfectly justified in making the submission that as a court of first instance, we should normally go there. Of course, here the situation is slightly different because there is a finding by the learned single judge that in a in-house appeal, lordship is appreciating that. Therefore, end of the day, lordship will have to see whether the view of the learned single judge is so erroneous.
Like the fountain head of the display. Here, no central service. This dispute has several components. But it starts with the notification of it. Then it was no agent can area of equivalence remains entirely within the state category. So there nothing. Once the names are forwarded, then it becomes a process accordingly. But we'll ask him. Equivalence has to be incorporated in the schedule of the. Can it be incurred without by administrative? Not go, but just to have a clear view.
Now, if your lordship would kindly have a look at definition of service matter, also lordship will get that distinction, my lord. 3Q at page 5 of the book. Service matters.
To merit me judgment.
Yes. Service matters in relation to a person means all matters relating to condition of his service in connection with the affairs of the union or a state. So it's not refers to only union, it refers also to the state. Therefore, my lord, section 14 and 15, that distinguishing feature which has been brought out has to be given a meaning. So as an employee of the state government, if I am aggrieved, I'll go to the state tribunal, I'll not go to CAT. So that's my humble sir. Now, my lord, as far as the judgments are concerned, as far as the judgment of our High Court of the Itanagar bench, my lord, that's a judgment lordship has pointed out, para 5 and 7 is the distinguishing feature. Unlike in the present case, my lord, where we are questioning the equivalence notification, no such challenge was there. Yes, as simple, my lord, respondent number 4 in this case, according to the petitioner before the High Court, he ought not to have been selected or nominated. That is how a challenge was laid. So it was a pure and simple matter which pertained to a recruitment to IS. So naturally, my lord, that view of the learned single judge of this honorable court in my humble submission is perhaps, my lord, I am not nobody to give a certificate, but perhaps it's a correct view. But here we are, my lord, concerned with a different situation. Now, the judgment which my learned friend Mr. Das has referred, that Rajiv Kumar in another case, if your lordship would kindly come to that judgment, here also, my lord, the facts are slightly different. What had happened in this case, my lord? A decision was rendered by the Central Administrative Tribunal. Now, the person who went to the High Court, he was not a party to the Administrative Tribunal. It was in that context, my lord, these observations were made. Since we all know a decision is an authority for what it actually decides. Every observation, every sentence in a decision may not be decisive. Therefore, my lord, to make the long thing short, my lord, my humble submission is, here is a case, it cannot be said that it's a case of total outside of jurisdiction of the Honorable High Court, especially in the context your lordship is deciding an in-house appeal, that aspect has to be given a due meaning, my lord. And secondly, moreover, my lord, we had 3 grievances. out of which 2 squarely falls within the domain of the State Administrative Tribunal. Since State Administrative Tribunal was not there, it would be, my lord, preposterous to say that I cannot approach the Honorable High Court. I can, my lord, I can make.
The three, your grievances?
Yes,
Your
three.
three grievances?
Yes, 3 grievances are regarding, my lord, first, their nomination of the 3 persons before even coming up with this equivalence notification that was put to Chennai. In fact, my lord, in the memo of appeal, the repetition prayers are there. The lordships will kindly
No,
come to
first-
pay
Your first grievance is regarding inclusion of those persons who are
in that list,
in that list.
Yes.
Second is exceeding the quota.
exceeding the quota.
And
And
is-
third is, my lord, that equivalence notification. So to say that in these circumstances, we could not have approached the learned single judge is absolutely wrong. And the view which the learned single judge has taken, of course, my lord, since lordships, eventually the main writ petition is yet to be decided. Lordships can always say the observations made by the learned single judge or the learned single judge who decides will not be prejudiced by any observations made. So therefore, that's my humble submission, my lord. That's my humble submission.
My straight submission is, Lordship, the statement made that the Assam Administrative Tribunal is not functioning or it has not been established is totally incorrect. It has been functioning for last 2 decades. Even today it is functioning. 5 years ago it was functioning. 20 years ago it was functioning.
My lord,
Every
this is
day-
a, sorry, this is a tribunal under the State Act. This is not a tribunal under this. The tribunal which is functioning in the state is under the Assam Act, not under this Act.
This is the problem. When I speak, I never interfere. Hota hai, Lordship. So I am used to it now. I'm having the skin of a rhino now. So his 3 grievances, as just now it has been spelled out. One is exceeding the quota. That not 1, it is 2. And then notification of equivalency. And the first one was recommendation of 10. Regarding recommendation of 10, that lordship will find at page 70.
You are referring to which paper book?
Paper book lordship, writ appeal 167.
Yes.
So this is the minutes of the meeting dated 18/9/2017. This is under challenge.
Page number?
Page number 70. Here the basic decision was, if lordship is pleased to come to page 70, 15 number of non-SCS were recommended for consideration for nomination to IS by various departments, which are as follows. 15 names came, and after the meeting, lordship 10 were recommended, page 71. So this is their grievance. I fully agree. There is no quarrel on that. So they have challenged it. Now their submission that they are aggrieved by having 2 numbers of from non-SCS category. Where is the challenge? For that, they have just now placed the minutes of the 21st December, which lordship will find at page 113.
This recommendation 10 persons, this 10 persons includes those respondent number 8 and 9.
Yes.
That includes out of 10 we have recommended. The central government in their meeting, the selection committee
Serial number
choose
1
2.
Yeah, ultimately serial number 1 and serial number 8 got nominated.
Yes, no, nominated. That minutes lordship will find at page 113.
And these persons were joint commissioner of taxes and assistant commissioner of taxes.
No, one is industry department, lordship, if I'm not wrong. One is industry, one is tax.
Industry, whatever it may be, but on 18/9/2017, they were recommended.
Yes.
10 persons were recommended,
These 2 persons.
including and 8 others.
Other 8 persons were
Yes.
recommended. And these 2 posts were declared as equivalent to this CS services in October,
in October.
and their names were recommended in September.
The meeting is on December.
This is what the meeting, minutes of the meeting.
This is although the word selection committee, it is basically a screening committee.
Minutes of the meeting of the selection committee for.
This selection
of
committee
list
is
of
not
non-SCS
selection committee as
officers
per
to be
the
recommended
rules.
For nomination of IAS for the select list 2016 held on 18/9 at 12 noon in the office chamber of the chief. Secretary,
Absolutely,
Assam.
Lordship. This selection committee is not the selection committee as envisaged under the IS rules, regulations of 1997. Lordship will see the members here. Lordship will see the members. VK People Senior Chief Secretary.
So why this speaks about this minutes of the meeting of the selection committee?
They have loosely used this term. This is in the Arunachal case, they are saying the screening committee. Here, Lordship, what is their intention? Lordship will see 15 non-SCS were recommended for consideration for nomination, and they have got 15. So to the central government for the main selection, 10 were sent. So this has no statutory backing, this committee. The state government could have sent all 15 also to them. This committee consisted of chief secretary, the additional chief secretary, the principal secretary, commissioner and secretary of the training and environment forest department. 4 persons were there. Now Lordship will kindly come to page 113. This is the actual selection committee. That selection committee, Lordship, has the backing of the statute. I'll just place it. Selection committee. That 1997 regulation. Yes. Page 53. Lordship may kindly come to page 53. The Indian Administrative Service appointment.
Yes.
Now, page 53, definition 2D, committee. Committee means the committee set up in accordance with regulation 3. Now, regulation 3, next page. Constitution of the committee to make selection. This is the selection committee as under the act. There shall be constituted a state cadre or joint cadre specified in column 2 of schedule. A committee consisting of the chairman of the commission. Commission means UPSC's commission. Or where the chairman is unable to attend, any member of the commission representing it and other members specified in the corresponding entry of column 3 of the said schedule, provided no member of the committee other than the committee or the member of the selection commission shall be a person who is not a member of the
Mr. Advocate General, all these are the merits.
The other side, I am responding to them. I am
Not other
in my submission. I did not take your lordship to all these provisions.
The reference to these regulations 1995 and 1997 was made by the Mr. Das.
No.
He has referred to these regulations.
No.
In support of this contention that this writ was not maintainable.
Because there is a service matter.
Service matter, that's
so it goes before the CAT L. Chandra Kumar. That's why I was showing it.
You have shown that. But here, if you are saying that committee was not the real committee.
No,
and
no,
that
real committee,
was
that
only
committee has a role. That
was
committee,
seated in December 2017 or all.
no,
That is the question of merit.
merit, just now they have said three prayers. What are on three prayers? The third prayer, they said that we are agree by give as because the state government has decided to give or earmark 2 posts for non-SCS. To
That
that
is-
I am responding.
In excess of the quota.
In excess of the quota, in excess of the quota, the minutes of the central government that is referred. And that minutes has not been challenged. 21st December 2018, 17. That is not under challenge. So what they are saying is totally not applicable here, not relevant here.
That is their point to this in respect. of
If
the
they are really
locus-
agree,
In respect of the locus of the petitioner association to raise this point before they, by way of filing a writ petition. And their argument is that since they have exceeded the quota and therefore we are agreeing.
Yes.
This is what their.
this is what they are,
argument
and that is why I'm saying they have not challenged that part.
is. So that is that.
Then I'm stopping. If Lordship, I am, whatever I am saying, it is not for the first time I am saying, I am responding to the other side. If the state government decision to have 2 posts earmarked for non-SCS, and this is their plea, it is my duty to point it out the correct position. The correct position is that on 21st of December, the central government,
Regarding.
and they referred and read this paragraph.
Mr. Advocate General, so far as regarding the question of maintainability of the writ petition before the learned single judge, you have raised your arguments and they have also raised their arguments that will decide only on the count of cases.
Sometimes it is required because they are trying to, I'm not using the word mislead, but what they are saying, it is not there in the petition. The pleading
Trying
is
to
totally different.
Influence the court. Not mislead.
Okay,
but
I'll use
influence.
another euphemism. The thing is, the Lordship, they have to challenge it. They have not challenged that part also.
That's my.
And number 3, Lordship, tribunal is functioning. And one other submission that I have given a wrong fact to this honorable court, the persons whom my learned friend may have represented, they are subsequently appointed or not recommended, not prior to 2016. Highly obliged, Lordship.
The query which was put forward by Honorable Justice Manshan to my learned friend Chaudhary was in respect of the 2 posts, which is earmarked for non-SC, it exceeded the quota. That's what he said. And thus the query which was put forward was that it is an association. How you are agreed with an association. Now, these 2 posts, which is earmarked for non-SCC and which has been sent by the government to UPSC for consideration for selection. This what my learned friend, which I support, is 21/12/2017 has not been put to check. If they are really agreed, so if they are agreed by 2 posts, association has come in, and these 2 posts they have not put to challenge. That's what my argument is also.
That's correct, but you see, just leaving aside the other contentious issues, at some stage, wherever this matter is decided, whether in a single judge or CAT or wherever, perhaps it will also be an issue once there is a statutory rules under 309 of the Constitution, which lays down a schedule which contains the equivalence post. Unless the schedule is amended by an administrative order, can the schedule of a statutory rule be tinkered with?
There are 3 different rules in operation. One is the taxation service rules, one is the industry service rules, the other one is the third one which they are relying is civil services code. The 3 rules are different. So somebody will have to take a call. Which are the equivalent posts? So there are various parameters. One parameter is the pay scale.
So far as
How the pay commission.
So far as regarding equivalence is concerned, as per rule 3.3 of these Assam rules.
Assam Civil Service.
As per schedule, the equivalence can be declared. And without there being amendment in that schedule, what the brother is asking you, without there being any amendment.
That was never argued. That was not on deliberation. In my humble, from that point of view, we may never made argument. Even today also.
Deliberation, we just want to
Yes, now the observation of the learned single judge is very clear. There should have been amendment in the civil service rules. In the civil service, and the ground is that the posts which are given equivalent, those posts are not included in that code. Whether that is required or that is not required, that is another area.
That is to be decided.
That is to be decided. That is have to look from a different perspective.
That's right.
How can it, suppose taking the other way out? So in the taxation department, how the civil service officers can be included there? So therefore, the government have to find out a mechanism which is acceptable without violating any of the norms. Deeply obliged, Lordship.
Judgment reserved.
Deeply. हमारा पता सिंह नॉय
Passover matter, supplementary 26 and 27.
Would it be taken today or tomorrow, Lordship? Because during the whole 1 hour also, I was doing case in the entity online. Tomorrow, Lordship. No, in fact, I am more prepared for that case only today.
This case.
Yes, Lordship, the case which is now called. The 26.
Now come. If you are prepared, then please come.
Let it be done tomorrow. I am exhausted, Lordship. Actually. From 10:30, 15 onwards, continuous. Even the lunch hour, whole hour also I have taken. Tomorrow, Lordship. Because I do not want to restudy again.
We don't want to fix this case. We are not fixing this case at a particular time. Whenever the number comes. Please.
Yes.
Today it was fixed at 2 o'clock only because.
So in fact, we made an observation, but if the list is over before 2, then what?
No. I am always there, Lordship. It is not that.
It is tomorrow and we'll.
When I said 2 o'clock, I made the request at 2 o'clock because of that NGT. Otherwise, I would have been in Delhi today. I skipped that and opted for the online.
Tomorrow we suppose.
No, there is nothing.
There is no such.
No, there is nothing.
Then tomorrow.
No. Because I have to study again if I get it delayed.
Item number 26 and 27 tomorrow.
Tomorrow, Lord. Highly obliged.
Passover matter 3 to 6.
Date may be fixed, my lord.
Yes.
Date may be fixed, my lord.
Why? Mr. Chaudhary was here now. What Mr. Chaudhary? Here, please, ma'am.
Lordship, today prefer some condition mandate, nothing else.
So we have already said that, call Mr. Chaudhary, where is the question of accommodation? Call Mr. Chaudhary, he was here only, please. Now, we are not supposed to sit idle here. Please call.
Lordship, he is
In the morning, you asked for accommodation,
Lord.
we have already granted you, now you can't please. Or otherwise, we'll decide on merits while going into the material available on records. Please, argue it out. Mr. Chaudhary is the only consider in all these petitions?
Yes, my lord.
I accept.
It's, I don't have to, my lord.
But there is no stay in item number 3. In all other cases, there is a stay. All other.
Item number 3.
My case, I'm telling, my case, there is no stay. On PPP, on basis, it was settled with me. 1 year I ran, thereafter government decided to float an item. And they cancelled it
Yes,
without information to us.
yes,
So
without
now my
giving
lord,
any
against-
opportunity of hearing.
Yes, against that order, we are before this court. By that time, we came to know that it has been given to a party by putting a tender. So we thought that let us put an application for implement of that party. By 491, that's fly 491, notice has been issued, we have taken steps. Now that party has been implemented.
The question is whether this managing director of the AFDC was clothed with the power to settle the
That's true. That's
question is on PPP mode or not.
That's true.
This
That's
was the
true,
core
my-
question.
Yes.
Argue it out whether he has the power. It's okay if that managing director has no power. Then certainly there is no illegality in the order of the learned
There
single
is
judge.
one, sir, I could not do it properly because there was no stay. And I was concentrating in those posts, but 3
Now
points.
it's very sad.
No, no,
Mr.
your
Das,
lordship,
the
3
problem
points.
is that
My lord, 3 points your lordship has raised on 3 points. One is that whether he has got the power. Because there is a, definitely I'll say, my lord, that's the best way is to protect it. This is what they decide to protect. There is a one judgment of this court in 2001. Their judgment says that there is a rule, fishery rules are there. But Assam Fishery Development Corporation doesn't have the rule. So certain guidelines they have to follow. From 2001, no guidelines have to lay down. It is only by one agreement they are there's a contract between 2 parties. That's one of the judgment.
when the full court of this court
Yes.
has already held that only by way of this tender process, the fisheries can be settled. This is the law.
That's a Aurobindo Dasma, that's a case of this court decided because there is a fishery rules like that. Now, this is Assam Fishery Development Corporation. Like. Kindly see the judgment, my lord, of this court. Last paragraph, kindly see 31 paragraph.
Which judgment you are referring?
That's a full bench,
Yes.
2001 SCC online Guwahati 17.
Yes, yes,
See kindly 31, my lord,
yes.
31. 3. While laying down the guidelines or regulation or to the spirit of the fishery rule may be given due weightage consideration. Fishery rules were enacted to provide stimulus the fish production healthy population which is engaged with the occupation of fishing. Under the fishery rules, preference is given to the cooperative society formed by 100% fishermen belong to scheduled caste community and minor community of Kachar. Hence, the AFDC is directed to lay down a definite guideline in the matter, so that there is no ambiguity. Till now, they have not framed any guidelines.
That's altogether another thing.
This is
The
the
question
judgment
is-
of the full bench.
The question is whether settlement in favor of the persons by the managing director of the AFDC is in accordance with the law or not. That was the
But that's, my lord, there is no guidelines. In the fishery rules,
guidelines, that doesn't.
my lord, in the fishery
You
rules-
satisfy on this point with this, that gentleman has the power to do so, certainly will rule in your favor. If he will not be able to, then we don't find any illegality in the order of the learned single judge. This is what I-
My lord, there, in my lord, your lordship, this what it details, any settlement which is made. So cooperative society with from 100% excellent fishermen, that's guided under the fishery rules, man. This is under the fishery rules. Which normally a settlement takes place under rule 12. There is a rule which is over Assam fishery rules. But as there was no rules over Assam Fisheries Development Corporation is concerned, my lord. So what they have direct to lay down certain guidelines, which has to be ambiguity with that rules.
Where is Mr. Chaudhary? He was here.
Lordship, some difficulty, my lord, personally.
What personal, whether he is in court or not.
No, my lord, it's just left, my lord. Yes.
Left hand.
31st May. And on that day, we are not going to adjourn the matter, please.
In 2 matters, there is.
May I just say, my lord, after the interim order.
So only 31st May.
April, May, my lord.
Sorry, not 31st of May, I'm sorry. 30th of April, sorry.
It's applies.
I'm already in the May.
Your lordship, party, man. You already we have taken a justice service. Otherwise, I will not be.
But here, if a requirement is there, we'll certainly implement. That's the
Service is
30th of April.
Service is complete. So for the private.
Time will not be given, lordship, that may be recorded. On
Yes.
that time will not be given, lordship.
To whom?
Anybody, lordship.
Okay. May then.
Daily list.
Much.
We are out of revenue, lordship, during these days.
Have you raised any objection when we ask for the adjournment or accommodation?
No, he has
You have
not.
not raised any objection.
No, he has
At
not.
that time You were sitting there, and since the court is raising objection, now you are saying, don't give them time.
No, actually, as a senior member, lordship, I thought. Actually. I thought he will come on tab 2, lordship, that is it.
The matters are there.
Daily list for hearing, item 15.
May I please, your lordship? My lord, there is order dated 9/6/2023, my lord,
9/6.
2023. from the fourth paragraph, in consequence of the order dated 5/12/2019 passed by this court in IA number so and so, the Registrar Judicial of this court conducted an inquiry and submitted a report on 21/2020, wherein no positive conclusion has been given as to whether the writ petition in question was filed by a genuine person, namely Jaidev Das, or the same was filed by an impersonator. It has been further indicated in the report that without proper examination of the signatures by the professional experts, it will not be possible to come to a conclusion.
That inquiry has already been concluded.
That inquiry completed, Your Lordship, by this order directed the SP to file a
There is no
report.
impersonation.
No, my lord, that report has not come.
That report is there.
He has said that I have collected the Vakalatnamas, send it to the FSL, but the FSL report is awaited. And this is of October 23, my lord, 16 October 23.
This 3rd of November 2023, there is a report from the Office of Superintendent of Police, Dugri.
It's marked X. Your Lordship will see the X report, report X, marked as X.
No, 3rd of November 2023.
Okay, ma'am.
Report is there.
Madam.
Further, it is informed that FSL report is duly collected by the so-and-so, where Rakesh Sharma directed or so-and-so, arrangement and magnification. The person who wrote the blue enclosed signature stamped and marked S1 to S9 also wrote the red enclosed signature similarly stamped and marked Q1. Report along with so-and-so. The report is there. There was no impersonation.
I'll just have to check that, my lord. I didn't see, I checked in the morning. I didn't get that.
Now they are asking for permission. Let's
You were the respondent number.
I'm respondent number 1.
Before the writ court.
Lordship.
You are for the appellant.
Yes, your lordship.
The appellants were respondents number 5 and 6 before the writ court.
Yes, your lordship.
Were not appeared despite service of notice.
Yes, at that time, lordship, the appellant failed to appear before the single judge.
Now, what is your ground?
Lordship, today, lordship, I'm praying for time, lordship, because some personal difficulties, so that's why, lordship.
Should have asked the first instance to ask for
Lordship,
time.
because my colleague friend has already.
Yeah.
Hari Om, lordship.
Item 19.
May it please your lordship. I'm engaged in this matter yesterday, lordship. I need some time, lordship, 2 weeks time. A lot of revenue records to be examined.
The challenge is only the order passed in the review petition. You have
Yes,
not
yes.
challenged the order passed in the writ petition.
Review petition, lordship. Review petition.
That challenge is not maintainable. Look at order 47, rule 7. Have you challenged the order passed in the writ petition, Mr. Bapujari?
My lord, it has been challenged, my lord.
It has been challenged.
It has been challenged. If my lord may be pleased to come to the cause title.
No, where is the prayer portion?
Page number?
Page number 34 of the memo of appeal, my lord. Page number 34.
11,780.
To set aside and quest, we have challenged the both. The issue here is, my lord, way back in the year 1975, certain part and parcels of land, my lord, over which now the governor house, that is Raj Bhavan, is standing, that was acquired. Now, some persons claiming to be interested, my lord, on account of their predecessor in interest, filed this writ petition in the year
When
2006.
the land was acquired
My lord, it was acquired in the year 1975.
and you approached the court for compensation in the year,
In the year, the writ petitioner approached in the year 2016.
you are the writ petitioner.
I'm for the writ petition, Lordship. Yeah, Lordship, sometimes you may grant it to me, because I acquaint myself with the facts, Lordship, because I'm engaged only yesterday. I've not gone to the papers.
My lord, may I pray it on the third week of May, my lord? May I pray it, my lord, on the third week of May, my lord? Third week of May, my lord. Not subject to my lord's convenience.
Third week of May में लगा दे. हो गया?
Item 21.
I'm so obliged. Lordship.
My lord, by last order, that is 7/3/24, Lordships directed that learned counsel for the appellant is directed to place on record gradation list dated so and so pertaining to the officials of the engineering and technical service of the pollution control board. Lord, what we find, the same document has been brought on record by the other side by filing an affidavit. Where so?
On 9/4.
9/4.
We filed an additional affidavit.
9/4.
Yes.
That's why, my lord, we did not file it. That is the gradation list, my lord. Page 431 of that affidavit. Isn't there a record?
I just.
It's a notification dated 18 December 23.
No, 9/4, what you have placed on record? What documents you have placed on?
Amongst others, my lord, they have placed on record the latest, my lord, gradation list.
affidavit.
Gradation list, yes. It reads as final gradation list is hereby notified at page 431. My lord, serial number 24 onwards are the appellant. And serial number 35 is the writ petitioner respondent number 1. Respondent number 7, sorry. 7, huh? What are you saying?
Hmm?
So there is a stay of this order.
Yes.
Your clients are continuing.
In fact, he has also been promoted. The respondent with petitioner, he has also been promoted.
And as per the gradation list, he is at serial number.
He is at serial number, my lord. He is below us.
He is below us.
Yes, below us. He
In fact, your
is
lordship-
at serial number 35, my lord.
In fact, your lordship. the
And
very
we are at
promotion-
from
The
24
very promotion of appellant number 1 to 5 and upgradation of appellant number 6 to 10 to the cadre of assistant executive engineer from the cadre of assistant engineer, that is the feeder cadre, which was given effect on 8/9/2020, was set aside by the honorable single judge. At my,
Upgradation or promotion?
1 to 5 have been promoted and 6 to 10 have been upgraded
And upgradation has also been,
in 2020, your lordship.
no, upgradation was also set aside by the.
Yes, your lordship. Yes, your lordship. In para 32, that has been set aside. Four
The
questions
state-
were framed. Now, the issue is that for 6 to 10, it's an open and shut case. The reason is very obvious. Because the rule, the regulation which has been framed under the statutory rules does not provide for upgradation. Yes, I must admit honestly that there can be upgradation of post, but there cannot be upgradation of the employees. You upgrade the post, then you promote. Because Rule 7, the Regulation 7 categorically says the modes of appointment. It's by direct recruitment, promotion, deportation, compassionate appointment, and contract. No upgradation.
No.
First of all. Secondly, the Rule 9 categorically states that this post has to be filled up by promotions. So where the question of upgradation comes? Your lordship, this upgradation has become the business of the pollution control board.
These respondents were not having the, this qualification.
Yes, I'll come to them.
Yes, yes.
Then they don't, as regards the qualification, they don't possess the qualifications. Now, if at all, they could have been promoted on two counts. Either the rules request to be amended or they challenge the rules, which is not in this case, your lordship.
Then the rules are amended the one and the same thing.
Yes, your lordship, but that is not the case. And most importantly, your lordship, the honorable single judge has dealt in details from para 27 to 32, why this is bad in law. And most importantly, your lordship, here's, if your lordship remembers, a submission was made that there was exigency of service. What is that exigency of service? 15 graduate engineers were there. They have ignored everybody. In the minutes of the meeting of the selection committee, even we are not considered. This was direct pick and choose policy. If I may draw your lordship's kind attention to page 114.
I think it's my appeal, I better.
Yes. Let him start. I'm sorry. Sir,
Or we can start on some other day. Today there's hardly, it will take some time, my.
And lordship, the interim order is in respect to the order passed by the learned single judge, setting aside their upgradation and appointment. Now, what happened? On 10/4/2023, I filed a stay vacating application. This order need to be vacated. Then, yes, your lordship, then the matter was being heard. And it raises the eyebrows of the then honorable court, which was sitting. And then an observation was made. Why this respondent was not promoted? He should have been promoted. Then all of a sudden, the Pollution Control Board became wise. And on 3/5/2023, they said, we are holding a DPC and we'll consider him. And on 16/5/2023, the minutes of the DPC was produced before this honorable court. And the court said, okay, fine, he's promoted, we'll hear you. And therefore, that order was passed, the seniority and everything will be taken care of, subject to the outcome of this writ petition.
In fact, their entire selection process was set aside. It is only on interim order they're continuing, Your Lordship. So it's not a case of seniority. It's a case where I'm
Now,
challenging.
So far as regarding promotion is concerned, you were also granted promotion,
Yes, Your Lordship.
but your grievance is regarding their continuance on the promoted post.
Yes, they cannot, Your Lordship. Because this promotion is violation of the rules, Your Lordship. And Supreme Court, Honorable Supreme Court, as well as this court has categorically stated, there cannot be any relaxation with regard to the conditions of recruitment.
Gradation can't be treated as a promotion.
Exactly, Supreme Court in
My
Santa
lord.
Kumari case has said that. But it has been given in that guise.
Promotion is a condition of service, my lord. Promotion is,
Gradation, but recruitment through upgradation by way of
there's a provision, my lord. My learned friend has made a wrong statement. There's a provision. Within the cadre strength, they can. Obtaining approval of the state government. My lord, while granting stay, a lengthy hearing took place in this case, my lord. Quite substantial. His senior was there, my lord. I think it was argued for almost
In fact,
a
I
lengthy
have
hearing.
the matter, Your Lordship, on that day. Your Lordship, there is upgradation of post is permissible.
Ultimately, it's a stay only.
Yes, Your Lordship.
They have
No,
to
the,
hear
and
the matter finally.
yes, Your Lordship, because their main intention is not to continue the matter.
Not to?
The main intention is to take time, Your Lordship, so that by the time they get retirement and the
They
case
are
get
not
interested.
seeking time today, we are.
No,
seeking
no, no,
time.
no, I'm not saying that.
They are not seeking.
My lord, I don't think we have taken a single adjournment in declaration here. One or two cases may so happen, my lord, I'm tied up in some other court. Normally, my lord, we don't seek adjournment like this. That's why I'm sitting up to 4 o'clock.
7th of May.
My lord,
Your Lordship, can
7th of May is election, my lord.
can it be on 9th of May?
7th of May.
It's an election.
Holiday.
9th of May, Your Lordship?
Then 14th of May.
14th. So, ठीक है.
Your Lordship, can it be on 14th of May?
हाँ, ये जमदूत का माती दिया है.
May it please, Your Lordship, can it be on 9th of May if it's not inconvenient to this?
9th of May, I think so we already.
There is a full bench also, my lord. I'll have some difficulty on 9th of May. There is a full bench.
14th.
Then 16? Lordship, can it be on 16 then?
Oh, 16, no problem.
In fact, we had deliberately we have put it on hearing day, 16th, okay?
Item 22.
Deeply obliged, Your Lordship.
I came prepared. Only thing is there is no time left, my lord. In fact, in that case, Lordship has asked us to find out a judgment. And which we could lay our hands.
Fourteenth May.
Well,
Yes.